it pleases the chair.
Good. That's what I am pleased.
I gotta find the roll.
Yeah,
I'll put that on the record.
Oh, okay.
Ms. Maxwell, are we going to go directly into, are we going to do the first part of our agenda and then go into our formal hearing, or are we going to just go directly into our formal hearing?
Maybe as opposed to like adopting the minutes and
Yeah.
the agenda.
We can back up and get that later. We just do what?
Do that first.
Okay.
Yeah, we don't have it sitting there in front of us.
It's on
I've got one.
iPad.
It's on your iPad.
If you don't see it, just scroll
Okay.
down.
Okay.
Judge.
And it's not under the cover
Very bottom.
sheet. The cover sheets have nothing behind them, they're just there for looks. So,
Ms. Maxwell,
yes.
what I always do in my hearings is I'll have roll calls during the hearing
Okay.
and ask if there's a quorum and do all those little procedural things. So if we go right directly into the contested case hearing,
Okay,
then I will be glad to do that.
okay, that's, is that helpful?
If that pleases the court, I think Judge Safley, you are in charge.
Okay, well, let's go ahead and go on the record then.
Let's-
So are you ready?
I am.
If I could, though, I would like to have the liberty of calling this real estate commission to order.
Steve, are we on? We're on.
We're on. And I would like, at this time, we will go back and cover the things that are on our agenda. But at this time, I am going to call on Judge Safley, who's the administrative judge for this matter. I'm going to give her the floor, Judge Safley.
All right. Members of the commission, today is December the 5th, 2012. We're present in Nashville, Tennessee for a hearing before the Tennessee Real Estate Commission, which will consider the case of the State versus Mr. Eugene Thomas III, docket number 12.16-11864-0A. I'm Joyce Grimes Safley, and I'm the administrative judge who's been assigned by the Secretary of State to preside over the hearing of this matter. I know that this is an experienced commission, and you hear quite a few contested case hearings, so I'm going to go very quickly over some of the instructions I need to give you primarily. All right, I will make all rulings today regarding the order of proceedings, admissibility of evidence, and procedural questions of law pursuant to the authority granted to me by the Tennessee Administrative Procedures Act. In other words, it's my role to conduct the hearing, regulate the course of the hearing, and rule on any evidentiary or procedural matters involved in this hearing. The board itself, as you know, the commission will make any rulings regarding the evidence and the facts that will be found and the decisions whether or not discipline is needed in this matter. At this time, I'm going to ask the state's attorney to introduce herself for the record.
Hi, Robin Ryan.
All right, and is Mr. Thomas present? Mr. Thomas? Mr. Eugene Thomas? All right, let the record reflect Mr. Thomas is not present. Do you have proof of service on Mr. Thomas?
I do, Your Honor. Let me put that on for a moment, please. I sent this by certified mail on October 24, 2012, to the address we have on record at 2441Q Old Fort Parkway, number 3 and 404. It was signed for not by Mr. Thomas, by a Cole Fuller on 10/24/2012. To follow up on that, I had Ms. Julie Kropp contact him, both by email and by telephone, and I would ask Julie to testify for me on that, please.
Do you want her,
On
you
the
want the
record.
witness?
You gotta get the microphone.
Okay, Ms. Kropp, if you'll raise your right hand, please, I'll swear you in. Do you solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your full name for the record.
Julie Kropp.
All right, Ms. Ryan?
Thank you. Ms. Kropp, did you then attempt to contact Mr. Thomas?
Yes, I did.
What was the date you attempted to contact him?
I don't have a copy of it in front of
And
me.
let me put this in front of you and see if this refreshes your memory.
Okay. Thank you. I called Mr. Thomas and sent an email on Friday, November 9th, 2012.
Did you have a response to the email?
I received one this morning at 6:12 a.m. It also copied you on the email.
Did you receive a response to any of the phone calls you made?
No.
Did you call it more than one phone number?
I called the number which was on file with the Tennessee Real Estate Commission, and I received a message that said the number or code I've called is incorrect. I then called the telephone number that was listed for Mr. Thomas in a document included in one of the complaint files, and I reached an automated voicemail, so I left a message identifying myself and confirming that
And that date was when?
November 9th,
You stated earlier you received an email this morning at 6.
6:12 a.m.
And what did he say in his email? If the court pleases, I'm going to have her read the response to the email.
Okay. The email said, "Hey, Miss Julie, sorry, I'm just responding to your email. Unfortunately, I will not be in attendance at the hearing on Wednesday, December 5th, 2012, due to emergency with my son. If possible, you may reschedule and inform me, and I'll definitely discuss with my attorney to possibly attend a future hearing." I did respond to complaint number 201201200 on May 30th, 2012. I have provided same attachment on this email by fax to the the Real Estate Commission, as well as to Lori Breckler and Dave Patton of Reliant for their packages. In fact, I was in that office with Lori Breckler when it was faxed and put together for mail. Now I'm unsure why it was not noted, but please double check. I've provided it for you in 2 forms to make sure you are able to open. For the record, I do believe that this is a preposterous complaint by Christine Bagsby. I have never seen a first-time home buyer pay for any repairs on a house before purchasing it. Maybe an investor, but never a first-time home buyer, especially without notifying the seller's agent. She did have an agent, Ray Helmsworth, that did not even attempt to notify my agent, Lori Breckler, of such a payment for termite treatment, nor were we notified of a bad termite inspection at all. So it leaves me to wonder why I'm being summoned to a hearing for false accusations and not her agent who was working with her. It's all in the attachment. If you do reschedule the hearing, please notify me, and with the approval of my counsel, I shall be there. Also, my mail is generally received on my behalf due to sometimes working out of area. Sincerely, Eugene Thomas. And attached to that email were two, one has a file extension of .odt and one has a file extension of .doc. They basically look like Word documents, which he, as you can see, states are.
Is that the only contact you had from them?
That's the only response I
And that's
had.
the response to your email of November 9th.
Yes.
Your Honor, I have sent also things to him via regular mail, none of them returned. I am asking for a default this morning. I think it's clear that he indeed had service and that I don't know what his intentions are, but his intentions are not to be here.
Right. Ms. Ryan, would you like to make the proof of service, the return receipt, and the email exhibits and evidence?
I would indeed.
All right, the proof of service return receipt will be entered as exhibit number 1. The December 4th email from the respondent replying to a November, what date in November?
9th.
A November
Oh,
9th,
excuse me, the email, yes.
November 9th email from the state will be entered as exhibit number 2. I'll mark them. I think it actually makes it go quicker. It probably doesn't, but just humor me. All right, it's my role at this time to decide whether or not there's been sufficient notice such that the motion for default can proceed. Is it my understanding you do not wish to move for a continuance?
I do not.
All right. I find that there has been sufficient notice, and the state has done all of the things that it should do to require notice on the respondent. Therefore, I will allow a default to proceed. That is something that the board decides whether the board wishes to allow the evidence to be presented in default. But I've said that there's enough notice that the board can do that if the board wishes to. One other thing. I don't feel that there's really a motion for a continuance before me. If there were a motion for continuance before me, then again, that's a legal matter that the judge is supposed to rule on. I will say this. In the technical record at this time is the state's notice of hearing, which was sent out on October the 22nd and was filed with the Administrative Procedures Division. A pre-hearing order was entered by myself on November the 9th, 2012, and the state's witness and exhibit list was entered into the technical record and filed with Administrative Procedures on November the 19th, 2012. In the pre-hearing order, which was sent out, it gave very detailed instructions regarding how certain things were to be addressed, what the scheduling deadlines were before this hearing. One of the things that was addressed was where and how to file a motion or a brief or a response. A motion for continuance was specifically addressed on page 3 of the pre-hearing order. It stated that any motion for continuance shall be in writing and shall be filed with the Administrative Procedures Division prior to the hearing date. The movant, or the person asking for the continuance, shall schedule a teleconference hearing for the motion. It's noted that Mr. Thomas did not file any type of request for a continuance, nor did he contact the Administrative Procedures in any fashion regarding any of the issues or any of the procedures which were set forth in the pre-hearing order. So I would not entertain any kind of motion for continuance, and any such would be denied. All right, members of the board, at this time I'm going to ask you to, before ruling on whether to proceed in default or not, I'm going to ask you to identify yourselves for the record, and I'm going to ask Chairman Stevenson if there's a quorum of the board. Starting with Mr. Northern, please.
Isaac Northern, Commissioner for West Tennessee.
Grover Collins, Commissioner, Middle Tennessee.
Austin McMullen, Commissioner, Middle Tennessee.
Michelle Haynes, Commissioner, Middle Tennessee.
Bear Stevenson, Commissioner, East Tennessee.
Janet DeChara, Commissioner, West Tennessee.
John Grease, East Tennessee. Wendell Alexander, Commissioner from West Tennessee.
Chairman Stevenson, is there a quorum?
Yes, Your Honor.
All right. I'm going to turn it over to the commission with regard to whether or not the commission wishes to hear the evidence and proceed in default against Mr. Thomas.
I make a motion we proceed.
We have a motion by Commissioner DeShaw that we proceed in default in this matter.
Second.
And seconded by Austin, Commissioner McMullen. And discussion on the motion.
Mr. Chair, there was a reference to in the email from Mr. Thomas to him conferring with an attorney. I'd just like to know if there's an attorney of record for Mr. Thomas.
There is not.
Thank you.
Any other discussion on this motion to proceed in default? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries unanimously.
All right, Ms. Ryan, you'll be allowed to proceed in default. I have some preliminary instructions I'm required to give members of the commission. I'll give those, and then I will allow Ms. Ryan to call her witnesses and present her evidence. Members of the commission, you're reminded that during the time this hearing is being conducted, that you can have no discussion concerning this case outside the actual board or commission meeting here with the judge, witnesses, attorneys, and other board or commission members present unless all parties are present. Any evidence which is introduced at the hearing will be subject to the Tennessee Sunshine Law or Open Meetings Act, requiring that all board discussions and deliberations be in public during the commission meeting before all parties. At this time, I need to know if any of you commission members have any knowledge whatsoever of this case. The law requires you to disclose if you do have any knowledge of the case from any outside source.
No.
All right, let the record reflect that the commission members have stated they have no knowledge of this case from any outside source. All right, Ms. Ryan, opening statement.
Your Honor, if the court please, may I pass out a copy of the notice of the hearing to the commission?
Yes, you may.
Thank you. If the court please, they generally like to look and read it, review it first before I start, if that's okay with the
That's
court.
fine.
Thank you.
All right, Mr. Chairman, if you'll let me know when the commission is ready to proceed.
May I ask a question?
Yes, Commissioner Grease.
Your Honor, are we dealing with three different complaints here? That's what I just need to keep straight in my mind. May I ask counsel?
Well, I think she'll explain that in her opening statement.
Okay,
but
perfect.
The actual complaints are what's listed in the notice of hearing. And if you have any questions regarding the nature of the complaints or whether or not there's actually three, then you'll have an opportunity to question witnesses regarding it.
Thank you.
All right, everyone had a chance to look at it?
I think we're ready to proceed,
All
Judge.
right, and it's my understanding that members of the commission have copies of the law and the rules, statutes in front of them. Is that correct? All right. Ms. Ryan?
Thank you. This hearing today is about following the laws and following the rules. The proof will show that this respondent, Mr. Eugene Thomas, was sent 3 separate complaints. The evidence will show that he did not respond to any of those complaints, and that after one of the 5 main complaints, he was broker released. And the evidence will show he has not reaffiliated or even notified Trek. Proof will show that except for tomorrow at 6:13 a.m., he has not been in contact with Trek at all, and that we have not been able to get in contact with him. We are here because the evidence will show that his license does not expire until October of 2013. And while we have no proof, and we will not be providing any proof today that he is actively acting as a licensee, he would have every right to be active without action by this commission. The issues you will be hearing today are going to be limited to these allegations. That is, failure to respond to 3 separate complaints according to the rule and the law 6213-313A2, and the law that rule that says again that they have 10 days to respond, and whether or not those failures are a violation of 6213-312B14, violating any provision of this chapter, any rule duly promulgated and adopted under the chapter of the terms, or any lawful order by the Commission. We, as I said, are going to prove that he is in violation of Rule 1260-0202, which does require a 10 days response to any complaint. And while we have no response to the allegations against Mr. Thomas from Mr. Thomas, and we are not seeking any action on the substance of those complaints, just whether or not he's in violation of these rules. But because of that, we are seeking today that his license be suspended until such time he does respond, that he be, if appropriate, assessed a civil penalty, and that indeed he be assessed all costs of this matter. Thank you.
All right, Ms. Ryan, call your first witness.
I call Eve Maxwell.
All right, Ms. Maxwell. Ms. Maxwell, if you'll raise your right hand, I'll swear you in. Do you solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, Ms. Ryan.
Would you please state your full name?
Eve M. Maxwell.
And Ms. Maxwell, what is there a higher chair?
Thank you.
Is that better?
Yes, that's better.
What is your position with the state of Tennessee?
I'm the Executive Director of the Tennessee Real Estate Commission.
And as that executive director, are you familiar with the licensing files of Eugene Thomas III?
Yes, I am.
Can you tell me when he was first licensed?
Eugene S. Thomas III was first issued license number 320632 by the Tennessee Real Estate Commission on 10/20/2009, and he was issued a real estate broker license.
Okay. And what address do you have for him using that license?
He was with 2 firms. One he affiliated with as soon as he had taken and passed his state exam, and then he transferred to another firm, both located in Murfreesboro, Tennessee, at a later point in time, and he was broker released in February by the last firm with whom he was affiliated. February of 2012 he was released.
Well, let me deal with that first. Okay. Since he was released but in February of 2012, has he contacted Trek at all about the status of his license?
No, he has not, to my knowledge, contacted Trek.
What does the law provide about a licensee who has been broker released?
That a licensee must either affiliate with a new broker or put their license in retirement within 10 days following their release from their former broker.
And that is that Rule 1260-0202?
I believe it is.
If you could check for me.
Yes, it is Rule 1262-02.
That requires that he must do something? Please?
Correct. Within 10 days after the date of release, the licensee shall complete the required administrative measures for change of affiliation, temporary retirement, or if ineligible for temporary retirement, placement in an inactive status.
Can he practice in the profession prior or not?
No, that same rule goes on to say, upon the signing of a release by the principal broker for change of affiliation, the licensee shall not engage in any real estate transactions.
And you said earlier he was released in February of
He was
2012?
released on February the 14th of 2012.
What is the current date of his expiration of his license?
His current expiry date is 10/19 of 2013.
Thank you. Do you have any proof at all that he's been active since February?
No, I do not.
Nothing at all.
No, I do not.
Now, how many complaints have been opened against Mr. Thomas?
3, I believe.
3. Do you know, well, let me just ask you if you can identify this one for me. Yes. If you would look, please, and tell me the date that a notice was sent to Mr. Thomas?
In this particular
Yes, in this particular matter.
complaint?
Yes.
It was sent on 2/14 of 12 by certified mail.
It was sent on 2/14?
Oh, let's see.
What's the date of the letter, Ms. Maxwell?
The date of the letter was February the 3rd,
And
2012.
for what complaint number?
That's what I was trying to make sure I was looking at the right file here in front of me. That was complaint number 2012-00337.
On the first page of that document I sent you, there's a copy of an envelope that I received in your office,
Correct.
and it's addressed to Mr. Thomas?
Yes, it is.
And was it delivered to him?
It was delivered to the address and signed for by,
On the envelope?
on the envelope itself. Yes, I'm sorry. Oh, I thought you meant the certified mail. The Eugene S. Thomas Reliant Realty LLC, 640 Broadmoor Boulevard, Suite 100, Murfreesboro, Tennessee.
And what's the date?
The date that this was mailed was
Yes.
February the 8th of 2007.
Ms. Maxwell? If
February
you
the
could-
6th of 2012.
Ms. Maxwell?
Yes.
Could you look beyond and tell me whether or not that particular document was received or delivered to Mr. Thomas?
That document, which, as I say, was mailed on February the 6th of 2012, was returned to TREC, returned to sender, attempted not known, unable to forward.
And the date of that?
The date of that particular United States Postal Service note was February the 9th of 2012.
Was it then sent out again?
Yes, it was then sent out again.
What address?
To 2441 Q Old Fort Parkway, number 404, Murfreesboro, Tennessee, 37128.
And the date that was delivered?
The date that was delivered was delivered on 2/16 of 2012. It was signed for.
Did he sign for it?
No, someone named Tate signed for it. It might say Jamie Tate, T-A-T-E.
After the delivery of that document, did TREC hear anything from Mr. Thomas concerning this complaint?
No, Mr. Thomas did not respond to this complaint.
Thank you. If the court please, I'd like to pass this out to the commission and enter that document as my next exhibit.
All right, that'll be exhibit number 3.
Exhibit number 3.
Yes, sir. Exhibit number 1 would be proof of service, the notice appearing, the signed return. Exhibit number 2 would be the email response from December the 4th.
We don't have exhibit number 2.
Okay. You should have both of those. I don't know if Ms. Ryan.
I did not make copies of the, except for the service which is on the original document, you do not have copies of the email from this morning.
That's been entered as exhibit number 2. If the commission wishes to review that, I'll be happy to share my exhibit number 2 with the members of the commission. You want me to allow them to do that now?
Maybe they could wait. I'm sorry, we got it this morning and it was too late to get it prepared for you all.
here's what I'll do. When the board or the commission deliberates, I'll share the exhibits that I have that haven't been passed out individually.
If the court would like, I can have Julie go make copies.
That would be good. Thank you so much. All right.
Thank you. I'm going to hand you a document, and Ms. Maxwell, see if you can identify this document for me. Can you identify that document for me?
Yes, I was making sure I had the correct file in front of me. This was a cease and desist notice that was sent to Mr. Eugene S. Thomas III, basically instructing him to cease and desist from operating a company that was called Community Success Investments, LLC. That were engaged in unlicensed real estate activity in the state of Tennessee.
Was there a docket number or complaint number attached to that?
There was TREC docket number 201201200.
And what is the date that you sent?
The date that was sent by certified mail was May the 24th of 2012. It went to Eugene S. Thomas III at 2441Q Old Fort Parkway, number 404, Murfreesboro, Tennessee, 37128.
And could you look at page 3 of the document I just sent to you and tell me if you can identify what that document states?
The one from Julie Kropp to the United States
Correct.
Postal Service.
I'm sorry, I didn't hear what you said.
I'm sorry, it's from the United States Postal Service, and it was sent to Julie Kropp, and it's a track and confirm email, and it says current track and confirm information, label number 7006 2760 0004 7069 2080.
Is that if you look back at the first page, is that the number on the certified mail receipt to Mr. Thomas?
Yes, it is.
And what is the date it showed that was delivered?
The date it showed by the certified mail that it was delivered?
Yes. On the document you were just reading from the post office.
It was delivered to Murfreesboro, Tennessee on 5/26/2012 at 12:40 p.m.
And have you heard anything from Mr. Thomas concerning that complaint?
No, we have not.
Wonderful.
Not to my knowledge, we have
I'd
not.
like to enter that document as the next receipt.
Yes, I did. All right, the cease and desist letter of May 24th, 2012, along with the return receipt, certified mail, and the track and confirm notice will be entered as collective exhibit number 4.
Thank you. I'm going to hand you another document and ask you if you can identify this one for me.
This is the mailing information to Mr. Eugene S. Thomas III, sent May the 24th of 2012, certified mail 7006 2760 0004 7069 2059, and it concerns complaint filed against Eugene S. Thomas III, TREC docket number 201-201-196.
And the date it was sent again?
The letter is dated May the 24th of 2012.
And can you tell from that document if the matter was delivered?
It was delivered on 5/26 of 2012 and signed for by, it looks like Katrina Lintemuth. I can't really read the name
Is
of that
that the address you have for Mr. Thomas?
That is correct. That is his address on record with TREC is 2441Q Old Fort Parkway, number 404, Murfreesboro, Tennessee, 37128.
Did he respond to that complaint?
He did not respond to that
Court,
complaint.
please, I'd like to pass it out and enter that document as my next exhibit.
All right, that would be exhibit number 5, and it would be the May 24th, 2012 complaint, along with the proof of delivery of May the 26th, 2012. It'll be collective number 5.
Have you had any contact since the opening of these 3 complaints against Mr. Thomas from Mr. Thomas at all?
Not to my knowledge, no, we have not.
Okay. Do you have any other contact information in addition to the ones you testified about earlier?
Current contact information from Mr. Thomas? Our file has the Old Fort Parkway address, and that's the only address that we have on file for him in that.
What does the law provide concerning when a complaint is filed, a respondent must respond?
The respondent is instructed in the letter, and the law requires that they file a response. Our letter actually says, "You are hereby notified that you must send a sworn and notarized statement answer in duplicate to this office within 10 days from the date upon which the receipt was signed."
When do your records show was the very last contact, if any, you had from Mr. Thomas?
Let's see. I personally have never had any contact with him. But the last contact he had with our office was when he transferred firms, at least according to our records, when he transferred from Keller Williams in Murfreesboro to Reliant Realty in Murfreesboro. That was on February the 23rd of 2011.
Thank you. I have nothing further.
Members of the commission, do you have any questions for Ms. Maxwell?
Mr. Chair, I've got one question.
Okay, Commissioner Norton.
In the exhibits that were passed around, all of the certified mail were addressed to Eugene Thomas except for a couple. One I've identified as a principal broker, the others are Lori Reckler.
Your Honor, may I address that, please? You have in front of you, this was a complaint opened against other people as well. They are not before you today, and you should not be considering any of that. The document you have is just verification from TREC of this particular complaint file. So the only thing I'm asking you to focus on today are those things involving Mr. Thomas.
Any other questions for Ms.
Mr. Chairman,
Maxwell?
Ms. Maxwell, who did you say he was broker released by on February 14th of 2012?
On February the 14th of 2012, he was broker released by Reliant Realty, LLC, located in Murfreesboro, Tennessee, and the principal broker at the time of that firm was David Patton.
Yes, Ms. Collins?
I had a question. When did you say he was originally licensed as a broker?
He was originally licensed as a broker in Tennessee on 10/20 of 2009.
Well,
He had been previously licensed in Missouri.
He just transferred in?
he came through the non-resident application
Okay, that's what I
process.
did.
We did not, Tennessee did not have reciprocity with them, so he took the state portion of the exam, and he was previously licensed in Missouri from 7/14 of 2004 to 6/30 of 2010 as a broker officer. He did not appear on their license search this morning when I looked, but we do have a Missouri certification of licensure.
Do we know if he had any complaints in Missouri?
The Missouri certification of licensure, which we received from the state of Missouri, says that he had no record of disciplinary action at the time we received this, which was August the 25th of 2009, at his time of licensure here.
Commissioner Grease?
One clarification, Ms. Maxwell, on Exhibit 2, the email that Julie received this morning, there's, Mr. Thomas references his agent, Lori Beckler. He was not the principal broker or managing broker, is that?
No, he was not the principal broker of either of the firms with which he was affiliated.
Thank you.
And Ms. Maxwell, if I could, you testified that on February the 14th of this year, 2012, he was broker released from Reliant Realty. Broker released him. And at the present time, he is still in broker release because his license doesn't expire until October 2013. So he is currently in broker release status.
That is correct. He's been in broker release status since February the 14th of 2012, and our records reflected, as of this morning, that he was still in a broker release status
Okay.
with an expiry date of 10/19 of 2013.
Apparently, in his email, he thinks he did respond, and he attached some attachments.
That attachment was received this morning at 6-something a.m. I can't testify, but I can tell you that the documents I have in the file show no response. You're certainly welcome to ask her if she ever received a response.
Okay, did you ever receive a response, or maybe a response from somebody else that he thought he was included in?
No, we never received, our files do not indicate that we ever received a response from Mr. Thomas. I have not read the one that came this morning, but we have never received a response from him. We've never received a response that appeared to be filed on behalf of Mr. Thomas. The other individuals who responded in this matter responded from their own perspective and in their name alone.
So you did get a response from Lori Beckler and Dave Patton? Or we can't, that's not what we're talking about.
Let
Okay.
me just briefly interrupt and get us back on track if I can. And I understand the Commission's natural curiosity about some of the underlying facts, which the state is not presenting this morning. The two other people, or whoever other people had complaints against them, are not before the board. What the other real estate agents did is not before the board, and whether or not they responded is not before the board. What's before the board is whether or not Mr. Thomas responded. So, if the board would limit its inquiry to that, I would appreciate it.
Your Honor, I think my problem with that situation is if he was broker released, why was he attached the same notice?
Okay.
See
In
what
this
I'm saying?
matter, the state has decided, you have to look at what the state is actually proceeding on. The state is not asking you to find that he actually committed the acts which are alleged in the complaints. As a matter of fact, we don't even have the complaints before us. What the state is asking the board to do, as I understand it, correct me if I'm wrong, Ms. Ryan, is that to discipline this respondent because he has failed to respond to any of the communications or complaints sent to him. So some of the underlying facts are not going to be in evidence. They're limiting the request for discipline simply to the fact that the respondent has not sent a response or replied to any of the charges. Does that help?
Thank you.
Any other questions, members of the commission? Any follow-up questions of this witness, Ms.
No,
Ryan?
I do not.
All right, Ms. Maxwell? You keep your seat, I guess.
Well, she can't, because
Is
I've
that
got
the
another
official-
witness. No, I've got
Is that the
another.
official witness seat?
Yes, that is the witness seat for
All right.
today.
You may step down, Ms. Maxwell.
My chair will stay, though, so that'll be good.
I don't think anybody will sit in that chair anyway. All right, call your next witness.
I
Ms.
call
Ryan.
Julie Kropp.
All right, Ms. Kropp, you've been previously sworn in. You're still under oath. Ms. Ryan?
Thank you. Would you state your full name for the record, please?
Julie Kropp,
And what is your position with the state of Tennessee?
Assistant General Counsel and Board Attorney to the Tennessee Real Estate Commission.
And in that position, have you had occasion to review the 3 complaints that were filed against Mr. Thomas?
I have.
And let me back up for a minute. Why were these complaints sent to you?
All the complaints are forwarded up to me from the TREC office.
Stop you just a minute. It's natural to turn toward whoever's asking you the questions, and it's not like I want you to turn your back on Ms. Ryan, but if you'll sort of face the commission members and speak up a little bit, they can hear you. I think they're having a little bit of trouble.
All right.
Thank you.
What is the process when a complaint is filed?
The complaint is opened down in the TREC office. The complaint is then sent out to the respondent for a response. When that response is received, it is included with all the documentation that was sent with the complaint, and everything is sent up to the legal department and opened as a file that I then review.
And then what do you do with the review?
I prepare a monthly legal report consisting of multiple complaints, which are presented to you all in an anonymous fashion for a probable cause determination at the meetings, and then you all vote whether or not to dismiss the matter, send out a letter, or authorize formal disciplinary charges with authority for the respondent to settle by consent order.
I'm going to show you one letter and ask if you can identify it and the complaint to which it relates.
All right.
Yes, you may.
What is the date on the letter?
The date of the letter is June 19th, 2012.
And it is addressed to?
Eugene S. Thomas III, 2441Q Old Fort Parkway, number 404, Murfreesboro, Tennessee, 37128.
And the complaint number?
The complaint number is 2012-003371.
And was this sent by certified mail?
It was.
And was it delivered?
It was.
Who was delivered? What address?
It was delivered to 2441Q Old Fort Parkway, number 404, Murfreesboro, Tennessee, 37128, and it was signed for by an individual named Ann Alford.
And what is the date of that delivery?
The date of delivery, the receipt says June 20th, 2012.
And in the document itself, if you would look to page 2, and number 5, 6, and 7, the issues presented were, in this particular matter...
I'm sorry, page 2 of the consent order?
Consent order.
Page 2. The issues were that a copy of the complaint was sent to the respondent, Mr. Thomas, on February 14th, 2012, which was signed for at respondent's address on file with the commission on February 16th, and then as of the date of the commission's review of the matter, the respondent, Mr. Thomas, had failed to respond, and he was broker released from Reliant Realty on or about February 14th, 2012, and as of the date of the commission's review, the respondent, Mr. Thomas, had failed to complete administrative measures to either change his affiliation to a new firm or place his license into retirement.
Did he respond to that to you at all?
I received no response to this.
So you are, can I assume, or are you assuming that he got a copy of it, knew what the issues were as far as responding timely and broker release?
I have no indication that it wasn't received, it wasn't returned.
If the court please, I'd like to pass this out and enter that as my next thing.
That would be exhibit number 6. All right, so the letter of complaint dated June 19th, 2012, with a attached consent order and the proof certified mail return receipt will be entered as collective exhibit number 6.
Thank you. Now, I'm going to show you another document as soon as these are passed out and ask if you can identify it, but I'll let you look at it first.
Okay. Just
Could you please identify that document?
I have.
If you could identify the date and
Oh,
what the
okay, I'm
document
sorry.
is, please.
I'm sorry, the date of the letter sent was July 17th, 2012.
Concerning what case number or what docket?
2012-003371.
And was this the first time that was sent or a second time this was sent?
This is the second mailing of the same letter and consent order.
And what address was that sent to?
2441Q Old Fort Parkway, number 404, Murfreesboro, Tennessee 37128.
Was it signed for?
Yes, it was.
By?
It appears to say Katrina Lintermath or Linterworth. I can't exactly read the name. But,
And the date?
July 19th, 2012.
Did you hear from Mr. Thomas concerning that letter?
No, I did not.
I would like to enter that as my next exhibit.
All right, it'll be entered as exhibit number 7, the July 17th, 2012, second copy of the complaint, along with the signed mail receipt for July the 19th, 2012.
Judge, this is exhibit number 7.
Yes.
I got mine out of whack.
I'm going to show you another document and ask if you can identify this for us. Can you identify that?
Yes.
What is it?
It is a letter dated September 14th, 2012,
From
from me.
and concerning?
Complaints numbered 2012-011962 and 2012-012002.
Are those the other two complaints
They are.
concerned this morning?
Yes,
And if you look at the separate page, was that also sent by certified mail?
it was.
And was it delivered?
It was delivered to 2441Q Old Fort Parkway, number 404, Murfreesboro, Tennessee, 37128, and it was signed for by Audrey Flanagan on September 15th, 2012.
And has he responded to that document to you?
I've received no response from Mr. Thomas.
Thank you. If the clerk please, I'd like to enter that document, that's actually two-parter, it's the next exhibit.
All right, collective exhibit number 8, the document will be entered, and it's the letter of September the 14th, 2012, from Ms. Kropp regarding the 3 complaints against respondent, along with the certified mail return receipt form.
Top, I'm going to show you one final document, and ask if you can identify the documents and the date on that document.
This is a letter dated October 9th, 2012, from myself, also including another copy of the consent order. This is sent as a final notice to Mr. Thomas for complaints number 2012-011962 and 2012-012002.
Was this also sent by certified mail?
Yes.
And does it show delivery?
Yes, it was signed for at 2441Q Old Fort Parkway, number 404, Murfreesboro, Tennessee, 37128, by Alex Malone.
Is there a date on that?
There's not a date filled in.
Have you heard anything from Mr. Thomas concerning that final notice?
No, there was no response to the final notice.
Have you heard from Mr. Thomas at all except for this morning's email?
No,
Despite all these letters, you've not heard from him at all?
no.
I'd like to have that next document admitted as an exhibit, please.
All right, the October 9th, 2012 final notice letter regarding the 3 complaints against respondent and the certified mail signed receipt will be entered as collective exhibit number 9.
Have you heard anything about whether or not Mr. Thomas is still actively practicing?
No.
But in his email this morning, did he suggest he was or was not working?
No, he did not.
And how long does a licensee have under the law to respond to complaints?
The statute allows 10 days from their receipt.
If you would, for me, would you look at 6213, 312, let me... Okay. 312B, number 14, but starting with B.
Okay.
What does, don't read it, but tell me what B provides.
That the commission can refuse a license, suspend or revoke where it's been obtained by false representation or similar conduct, or where a licensee is found guilty of a number of things.
Okay, and what does 14 provide?
14 states violating any provision of this chapter, any rule duly promulgated and adopted under this chapter, or the terms of any lawful order entered by the commission.
And you had stated earlier the law provides in another section that he only has 10 days to respond.
Yes.
And you know the law concerning about, or rule concerning about when he must be re-affiliated?
Yes.
And how many days he has for that?
10 days.
And to your knowledge, has he done either?
No.
I have nothing further for this witness.
Members of the commission, do you have any questions for Ms. Kropp?
Yes, Your Honor, I have one. Don't reprimand me, but I'm getting ready to ask her something about, all 3 of these complaints, the 3 complaints that he has not responded to any, are there 3 different matters, or are they all concerning the matter in which we got our first piece of document?
I believe they were 2 different matters. 2 complaints were opened on the same set of circumstances. I think they were 2 separate matters.
Okay.
Any other questions?
The address,
Yeah.
what was his original address when he got his license?
I don't have that information. All I have access to, I think that would be a question maybe for Ms. Maxwell. I just had the current address
And
of,
we got that, did he do an address change?
that is what is listed in our regulatory board system. I'm not sure of the inner workings of that, but
That was my question on the address. Is this an office address? Because it seems that somebody different has signed for it each time. Is this a home address? Is this what kind of address is this?
when I pulled
I have no idea.
his name on the RBS system, this is the address under the name. I don't know of.
Because somebody is signed each time, but it's a different person each time.
And I
don't know
believe
that this witness can actually answer that. However, the board
Okay.
may want to review exhibit number 2, which addresses mailings.
Yeah, I believe he did reference in that email that sometimes things are signed for on his behalf due to travel in that email, but that's all I know of
Okay.
that.
But we just don't know if this is an office or a home?
I'd be happy to call Ms. Maxwell back to the stand, and she can give you that information.
Or, I don't guess it really matters that much. I'm just curious.
Sorry, I'm sorry, I just don't know.
What is the date when his current license will expire?
I don't have that information in front of me, but I believe it's sometime in October of 2013.
Okay, thank you.
Any other questions for Ms. Brock? Ms. Brock excused?
Yes, and I'd like to recall Ms. Maxwell.
Ms. Maxwell, you've been recalled. You're still under oath.
Ms. Maxwell, there have been questions about Mr. Thomas's address on Old Fork Parkway. What information, if any, do you have about that address?
When he first applied for his broker license with TREC, he listed the address 2441Q Old Fort Parkway, number 404, Murfreesboro, Tennessee, 37128. This particular home address has not been changed since he became licensed. We don't have a change of address in our files. When someone is affiliated with a firm, their mail goes to the firm's address. And when they are broker released or retired, no longer affiliated with a firm, then that mail is sent to their home address, their residence address, or the address that we have on file is their home address. And so that's why there was a difference in the mailing addresses that you saw.
Do you have any other further information about how many people live there or might live there?
No, I do not. Obviously, we don't ask that question, how many people live in your household, and I'm not aware of that. His license expires on 10/19 of 2013.
Do you have any other information showing any other address for Mr. Thomas at all, except for what he provided to you with this address?
For his firm addresses, he had two firm addresses as he worked for two different firms, and those were changed in our RBS system for his business address at the time the transfer went through. And then, as I say, when he was broker released, then his address defaults back to his home address. And this particular address at 2441Q Old Fort Parkway, we never received any change of address or any indication that he was no longer residing at that address.
Thank you. I have nothing further.
Any follow-up questions for this witness?
I have a question. Whenever someone is broker released, excuse me, what is the administrative information or administrative measures that are required of that person at that time? First
of all, when they're broker released, we receive a TREC 1 form, and the broker basically checks a box that says the broker releasing the person. We then send a letter to that individual, and that letter goes to their home address because that then is their address of record with us. And it tells them in that letter that's sent out, and one was sent to Mr. Thomas, that they've been broker released and they have 10 days from the date of the letter to either retire their license or to transfer to another firm, at which point the person is supposed to either send in a TREC 1 form that would retire their license or transfer them to another firm.
Why do we have that requirement?
So that licensees don't just sort of float about, I guess, unattended. In order to practice, you have to be affiliated with a firm. I mean, that's required by the Broker Act. And if you're not going to practice, we don't have an inactive status that you can choose. You can't sit home and become inactive. The only inactive status that the statute provides is one that TREC can put you in when you want to retire but have not fulfilled your educational requirements for renewal. And so if you haven't gotten that, we can put you in inactive status, but you can't do that. So you have to be in a status that is defined by the Broker Act, and basically one is active and one is retired.
Thank you.
Okay. I have a question, follow-up question along that same line, Ms. Maxwell. Does it say, the licensee is contacted, they've got 10 days, either to put their license in retirement or affiliate with another firm. In does it also say that if you do not have your education and you want to continue in an inactive status, then it's up to the agent to notify staff, notify TREC that they want to continue to be in inactive status until they get their education requirements?
Well, as I say, inactive status is not a choice that's available to a licensee to pick. I mean, it is a status that the statute allows TREC, mandates TREC to put a licensee in if they have applied through a TREC 1 form to retire their license, but they have not met the statutory educational requirements. So so the licensee will remain in that status until they get their education, at which point they'll roll over into a retired status automatically. But inactive is not renewable. So if you don't have your education and your expiry date comes, then your license won't renew, just like it wouldn't if you were active. So the licensee doesn't have to, they have to send in a TREC 1 form to tell us they want to retire. I don't know if that answers your question.
Yeah,
I'm not sure
because
really.
I know when they send in that TREC 1 form requesting their license be placed in retirement, and you realize that they do not have their education.
Right.
In order to do that, then they are notified, you do not have your education, you cannot retire your license, so therefore, you are being put in an inactive status with the commission until such time that you do have your 16 hours of continuing education.
Yes, there is a letter that's generated at the time someone applies for retirement, and it explains whether, they're placed in retirement, they're placed in inactive, has their expiry date, and even the broker release letter explains inactive status as well.
Okay.
So it's explained to the individual in both those letters.
Any other questions, Commission members?
If I could, Your Honor, I've been looking at the clock. I don't want to make this decision. But it's standard, every December meeting, the commission takes the staff, all the staff, which is, I think, 15 staff members. We're going to be going to lunch around 11:05, somewhere in that time frame. We can continue on, not take a short break, and we can continue on to about 11:05, and then take a break for us to be able to go take staff to lunch and then come back and reconvene at 1 if we're not finished. I just wanted to...
Whatever the commission wishes to do. If the commission wishes to forge ahead and see if you can finish before your lunch, we'll certainly do that. If the commission doesn't feel that you're going to be able to do that, I don't know how many more witnesses, Ms. Rhines.
I have no more witnesses. I have a short closing.
I'd like to see that.
Do we want to...
We're going to take a break.
Well, you want to take a break?
All right, well, we'll take a 10-minute recess then.
Okay. Thank you, Your Honor.
All right, let's go back on the record. Ms. Ryan?
Thank you. I have no more witnesses, but I'd like to make a short closing.
All right.
When you consider this morning, please consider that the issues before you are simply whether or not he responded timely under the law and whether or not he took care of administrative measures concerning being broker released. The complaint before you has the issues of the complaint that are alleged, simply because that is what was presented to him at the time of the consent orders. I am not asking you to look at any of the underlying facts for any of that, just the fact that that's what was alleged. This morning, we've got a man who has not followed the rules of the law. Your laws require that everybody file a response within 10 days. This protects not only the general public, but it protects the respondent as well. We all know that people will file complaints, and half the time they are baseless, or half the time we get a quarter of the story when there's a full story out there. That is why you have such a requirement, so that when a matter is presented to you, you can fully deliberate on that matter. In this case, Mr. Thomas was served with 3 separate complaints. He was given numerous opportunities to respond to the complaints. Ms. Kropp gave him more than one opportunity to respond. She even, unusually, sent final notices so that he could respond. And until today, at 6 o'clock in the morning, we have heard nothing from him. Moreover, he was sent notice from TREC that he was broker released and he had a responsibility to do something about that within 10 days, and he did not. Now, I don't know what he's doing out there, and I don't know that he is actually practicing, and quite honestly, we are not asking for a revocation because what he has done is failed to respond as opposed to sometimes what you do revoke on when you're stealing money. While you certainly are entitled under the law to revoke a license, we are asking today simply to have him suspended so that he cannot actively practice until such time he comes before you and addresses the complaints. We are all also asking that, if you please, to assess him a civil penalty based on the allegations and the violations of the law, and certainly that he be required to pay all the court costs in this matter. Thank you.
All right, members of the board, it's my pleasure and opportunity now to charge you regarding the law that you must apply. The board's heard the proof in the matter of Eugene Thomas. You are the exclusive finders of the fact in this case. You're also the exclusive judges of the application of state rules and statutes which govern real estate practice in the state of Tennessee. The board must make open deliberations, make findings of fact, and reach conclusions of law. You must determine the facts based upon the evidence presented. Any adoption of facts by the commission should be adopted by a simple majority by the commission. If the board decides or the commission decides that there has been a violation or violations of state rules and or statutes, the commission must then decide what discipline or action by the board is appropriate. The board may privately censure the respondent, issue a public censure or reprimand, place the respondent's license on probation, suspend the respondent's license for a fixed period of time with or without certain conditions or requirement, revoke the respondent's license with leave to apply for a new license, permanently revoke the respondent's license, and you may also assess civil penalties if the board believes such civil penalties are warranted. I mention these forms of discipline as examples only, in no way intend to suggest to the board what it should do. The notice of charges, which you should have before you, may be used in assisting the board in formulating your order. You are not to take as evidence the notice of charges. That's a pleading in this matter. However, you can use it as a guide. Ms. Ryan, did you have findings of fact, conclusions of law? Okay, I'll get those passed to you in a minute. The state has the burden of proof in this case. It's the state's burden to establish all the facts necessary to prove each and every violation of the allegations. A preponderance of the evidence means that amount of evidence that causes you to conclude that an allegation is probably true. You must limit your inquiry in this matter regarding violations of statutes and rules to those violations which are alleged in the state's notice of hearing. For instance, if you believe that the respondent violated another statute or rule which has not been alleged in the notice of hearing, the board may not inquire into that or address that. The Administrative Procedures Act, TCA Section 4-5-101 et seq. Specifically requires the board's order in this matter to contain findings of fact, conclusions of law, and the policy reasons for your decision. I will not read out loud to the board TCA Section 62-13-312 or Rule 1260-2.32, which the board has before you, and are the specific statute and rule which the state has alleged has been violated in this matter. But the board should have those rules and statutes before it. In determining whether civil penalties should be assessed and in what amount, the Commission may consider the following factors: whether the amount imposed will be a substantial economic deterrent to the violator, the circumstances leading to the violation, the severity of the violation, and the risk of harm to the public, the economic benefits gained by the violator as a result of noncompliance, and the interest of the public. All right, any motions to adopt findings of fact to find that the respondent has or has not committed the violations of the alleged statutes or rules The motions to formulate discipline, if any, and to state the policy reason for the board's action must be carried by a simple majority of the board. Unless there's further questions about my charge, I'll turn the proceedings over to Chairman Stevenson and let him begin the deliberations with other members of the commission.
Okay, as we have been presented with the testimony, heard the witnesses in the matter of Eugene S. Thomas III, number 12-18-11-86408. At this time, as the judge has directed us, we are to go through the findings of fact and figure out what conclusions of law, if anything has been violated, and the penalty in this matter, and also to have a policy statement in this matter as to how we think this proceeding has violated our statutes. And at this time, I would open the floor for any commissioner who has anything they would like to bring up and address at this time.
Mr. Chairman, I move that we make the following proposed finding of fact. Respondent was at all times pertinent hereto licensed with the Tennessee Real Estate Commission, having been issued license number 320632.
Would you like to put that in form of a motion, Commissioner McMullen?
That's my motion, that we adopt that as our first finding of fact.
Second.
We have a motion by Commissioner McMullen and seconded by Commissioner DeShaw. Any discussion on the motion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries.
Mr. Chairman, I move that we make the following proposed finding of fact, number 2. Respondent was at all times pertinent hereto until he was broker released on or about February 14, 2012, a broker with Reliant Realty, a licensed real estate firm in Murfreesboro, Tennessee.
Second.
And a motion by Commissioner McMullen, seconded by Commissioner Collins. Any discussion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries.
Mr. Chairman, I move that we make the following proposed finding of fact, number 3, and this can be found in part on number 13 of the proposed findings of fact that we were given by Ms. Ryan. Respondent was broker released from Reliant Realty on or about February 14, 2012.
Have a motion and a second. A motion by Commissioner McMullen, second by Commissioner Collins. Any discussion on this motion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries.
Mr. Chairman, I move that we make the following proposed finding of fact, number 4. Respondent has failed to complete the administrative measures for either change of affiliation to a new firm or placing the respondent's license into retirement.
Have a motion by Commissioner McMullen and it's seconded by Commissioner Grease. Any discussion on this motion? All in favor say aye. Aye. Opposed, no. Motion carries.
Mr. Chairman, I move that we make the following proposed finding of fact, number 5. 3 complaints have been opened against Mr. Thomas with the Tennessee Real Estate Commission. 1 complaint was served on Mr. Thomas on February 16, 2012. The other 2 complaints were served on Mr. Thomas on May 26, 2012.
Second.
We have a motion by Commissioner McMullen and seconded by Commissioner DeShaw. Any discussion on this motion? All in favor say aye. Aye. Opposed, no. Motion carries.
Mr. Chairman, I move that we make the following proposed finding of fact, number 6. Mr. Thomas failed to respond to these 3 complaints.
Second.
Have a motion by Commissioner McMullen and seconded by Commissioner DeShaw. Finding of fact number 6. Any discussion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries.
Mr. Chairman, that's all I have as far as findings of fact.
Any other commissioners have any motions they would like to put on the floor as far as the testimony we have had that would be part of our findings of fact in this matter this morning? Hearing none, then we will, these 7 findings of fact that Commissioner McMullen has provided us with and duly seconded and passed unanimously by each one, we will have these into the record as our findings of fact in this matter pertaining to Eugene S. Thomas III. Now it is our duty to continue on and find which parts of our statute of the conclusions of law have been violated.
Mr. Chairman, I move that we make the following conclusion of law number 1, that the respondent's act and conduct as set forth in the findings of fact constitute violations of Tennessee Code Annotated 6213-312B, relevant B14, the relevant portion of which reads as follows: the Commission shall have the power to refuse a license for cause or to suspend or revoke a license where it has been obtained by false representation or by fraudulent act or conduct, or where a licensee in performing or attempting to perform any of the acts mentioned herein is found guilty of violating any provision of this chapter, any rule duly promulgated and adopted thereunder, or the terms of any lawful order entered by the Commission.
Second.
Motion has been made by Commissioner McMullen and was seconded by Commissioner Collins. First, is there any discussion on the motion that has been entered into the record by Commissioner McMullen? Hearing no discussion, all in favor say aye. Aye. Opposed, no. Motion carries unanimously.
Mr. Chairman, I move that we make the following conclusion of law number 2, that the respondent's actions as found in the findings of fact are in violation of Tennessee Code Annotated Section 6213-313A2, which states that the accused applicant or licensee shall within 10 days file with the Commission the applicant's or licensee's answer to the complaint, a copy of which shall be transmitted to the complainant.
Second.
Motion by Commissioner McMullen. You've heard the motion. It's been duly seconded by Commissioner DeShara.
Question?
Have a question by Commissioner Northern.
Not a question, but would you repeat
The number?
code, please?
6213-313A2. Yes, sir.
Thank you for clarifying the motion. Any other comments or discussion on this motion as pertaining to additional conclusions of our law? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries.
Mr. Chairman, I move that we make the following conclusion of law number 3, that the respondent's actions as set out in the findings of fact are in violation of the Tennessee Comprehensive Rules and Regulations, Section 1260-2-.02, Part 1. I think it's a misprint of Part 2 on your proposed findings of fact, which states in pertinent part, within 10 days after the date of release, the licensee shall complete the required administrative measures for change of affiliation, temporary retirement, or, if ineligible for temporary retirement, placement in inactive status. Upon the signing of a release by the principal broker for a change of affiliation, the licensee shall not engage in any real estate transactions, nor shall he act under a contract with another firm until completion and transmittal to the Commission of a change of affiliation form accompanied by the proper fee.
You've heard the motion put on the floor by Commissioner McMullen. Do I hear a second?
Second.
We have a second by Commissioner DeShara. Any discussion on this motion made by Commissioner McMullen as far as conclusions of law number 3?
May I interrupt for a moment? Does the Commission have the most recent amendments to that year
Can you direct us to that?
It's still single number. It's just amendments. It's stated.
On the very first page right there.
Let me amend my motion, Mr. Chairman. I didn't check the pocket part. Yeah, so the reference should be, the findings were correct. I was looking at the old rule version. The pocket part has the correct version, and so the reference should be to Rule 1260-2-.02, Part 2, which I believe is correctly quoted there to say that within 10 days after the date of release, the licensee shall complete the required administrative measures for either change of affiliation or retirement, the licensee shall not engage in any activities defined in Section 62-13-102 until a change of affiliation is received and processed by the Commission. And so that would be my amended motion, would be to refer to that particular section.
Okay, thank you, Commissioner McMullen, and Commissioner DeShaw will second your amended motion. It's been read into the record and duly noted. Any discussion on this motion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries. Now that we have gone through our findings of fact and concluded what we have, and we have concluded the 3 statutes that have been violated in this matter, it is now time for us to start deliberating and decide what is the appropriate penalty to be assessed in this matter against Eugene S. Thomas III. Does anybody have any suggestions or any motions that they would like to put on the floor for discussion?
Mr. Chair,
Commissioner Northern.
in the consent orders that were forwarded to Mr. Thomas, the combined total of the penalty imposed based on those consent orders was $3,000, $1,000.
Yes, ma'am.
You all really can't consider that was just part of the documentation to what Mr. Cox said.
Okay, let me instruct. As a matter of law, you can't consider settlement discussions, which a consent order sent to the respondent in this matter, an attempt to settle the matter. You can't really consider them as like proof in the case, and it shouldn't bear on what your decision is in deciding whether or not there should be discipline or what discipline, if any, should be applied to the respondent. So other than the fact that these states sent that as a communication, the contents of that communication are not to be considered for any purpose.
That being the case, Your Honor, as a penalty for violation of Code 62-13-312B, Part 14, the regulations allow a penalty of $50 to $1,000, $1,000 being the maximum, and I would propose that we impose a penalty of $1,000.
I'll second that motion.
We have a motion that has been made by Commissioner Northern of a $1,000 civil penalty to be assessed, and it's been seconded by
That's only for that.
Commissioner Alexander.
What about,
That's for the one violation now. That
Right,
doesn't
it's,
include all of them.
right, it's just that for that one violation. We have concluded that there have been 3 violations, as read so eloquently into the record by Commissioner McMullen, and this is only on the first conclusions of law that we feel has been violated, and you have heard the motion, and it's been duly seconded. Is there any discussion? The $1,000 penalty.
what about, this is for discussion, what do we think about suspension? That was also requested.
Well, since we're just looking at the number 1 conclusion, the number 1 of our statute that we have concluded has been violated, the motion made by Commissioner Northern is only applying to that we can discuss when we finish our deliberation, and we can discuss what additional penalty we feel would be appropriate in this matter. So right now, we're just voting on the motion of Commissioner Northern that, based on 62-13-312B-14, that...
Mr. Chairman?
Yeah.
Commissioner McMullen wants to propose that as a friendly amendment. I have no objection.
Okay.
I will move to amend the motion then to also provide that the respondent's license be suspended through October 19, 2013, which I understand is the date on which the current license would would terminate, would expire.
May I speak to that?
Do we have a second on that motion? On that amendment to the motion?
I'll second it for discussion.
Commissioner Alexander has seconded the amendment to this motion of $1,000 penalty. Commissioner Grease.
Thank you, Mr. Chairman. Speaking to the suspension part of it, I think the intent, at least from my perspective, would be he's suspended till these complaints are satisfactorily handled. And so if he chooses to come in and respond to these complaints, either, I don't know, can he still do a consent order with Trek, or is it going to have to be a formal hearing at this point?
Well, okay.
We need instructions, Your Honor.
We're just trying to figure out how long, because I want to suspend
Okay.
him.
What we're here for today is discipline on him failing to respond. And that's what the state has asked for. I don't know what the procedures exactly are for him to apply to have the suspension set aside. I suspect that y'all have procedures in place that if someone's had their license suspended, they can go before the board and ask to have that license reinstated. And then the board could put certain conditions on that, if they want to reinstate it or they don't want to reinstate it, or they can require that the complaints be explained, or whatever the board wishes to do. But that's kind of getting on ahead of the board itself. In this matter, there's the only violation that the board's supposed to be considering is the failure to respond. And then as far as the suspension, whether or not, I mean, you don't know that he's even going to want to ask to have it set aside. We haven't heard anything from him. So the board will have to address that if and when that happens.
And I'm just going to say one quick comment. I just wanted to say, in response to a question you just had, this whole morning we have had a hard time staying focused just on that one issue that the state has been asking us to look at, and that is his failure to respond in a timely manner. And we're just, with that
Mr. Chairman?
being said, yes, Commissioner McMullen.
My concern would just be that we make sure that whatever the time period is or circumstances, that they be very clear, and that our order be very clear. And so, I don't know what it would look like, if he did show up, and I don't know what another satisfactory resolution of the charges looks like. And so maybe we could put some language in there to say, this date certain or further order by the board, and then, he could be incumbent upon him to come back in and to make some kind of showing that we ought to do something different. But that's just my concern, is that whatever time period or circumstances that we put in there, that they be very clear. And right now, that's to think about what some other resolution of this might look like really looks sort of murky to me. And it's hard for me to figure out how I write down how to satisfy requirements of something that looks so murky, trying to project into the future at this point.
As an example only, I would instruct the commission that with most boards and commissions, if an action is taken against a license and the respondent is not happy with that action or believes that the situation has changed or has additional information to offer to the commission, they generally will petition the commission or the board and set forth the reasons why the suspension should be lifted or the revocation should be reversed or whatever. So, just as an example, that may help the board or the commission.
Right now, right now before us, if I could just summarize, right now before us is a motion by Commissioner Northern, second by Commissioner Alexander, that a penalty of $1,000 be assessed, and we have an amendment on the floor to that motion to also include a suspension of the license of Mr. Thomas's license until October 2013. And we have an amendment on the floor that has not been voted on.
So I still open for discussion.
We're in the discussion phase on that amendment.
From my perspective, the goal would be to get him to answer the complaints.
But
And I'm not talking about what's in the complaint. I just want, he did not respond to the complaints. That's why this is in front of us.
Mr. Chair,
yes, Commissioner
I
Norton.
concur with Commissioner Reese that the primary objective was to get a response from the licensee, but leaving it in the manner that he's proposed would allow him to come in on the last day and offer some solution without allowing this body the opportunity to be able to respond. I would be opposed to changing it from the proposed amendment that's currently being offered by Commissioner McMullen. I think, as it's been pointed out, he has the opportunity to petition that we reconsider at any time, and he can do that. And it's not incumbent upon us at that point to do, if he doesn't, to do anything further. But if we put a timeline on it, then we've got to come back and deal with it again at some point.
You say a timeline different from the actual expiration of his license?
If it's a different timeline from the expiration of his license.
Right now, the amendment is that Commissioner McMullen has on the table that his license be suspended until October, is it a specific date? What is the specific?
October 19th.
October 19th, 2013, at which time, if this matter is not resolved, if he doesn't petition back to us, then on October the 19th, 2013, this individual, Mr. Eugene Thomas, will no longer have a license.
That's correct.
We're discussing the
I'd
amendment.
like to add something to that.
I don't mean to interrupt too much. I guess I do, because I am. But the board or the commission needs to understand that when the order that the commission enters is sent out, there will be instructions attached to that order about how to appeal the order. So essentially, if a respondent is not happy with whatever order the commission issues, there are procedures which are set out by statute under the Administrative Procedures Act, which give deadlines which the person has to act within a certain amount of time, or any chance to appeal or ask for reconsideration or whatever has passed. So I'm not clear if the board is intending to leave it as an open question whether or not he has to show up on or before October the 19th, 2013, or the board is simply stating that it wishes to suspend the license through that time.
And if I could speak to that, and also to address, I guess, the point that Commissioner Grease raised, I don't really look at this as something to force Mr. Thomas to answer, because I feel like he had his opportunity to answer. He didn't do it. He's not here, and the trial went forward without him. And so now it's just a question of what's the penalty for that, and that's why I think we ought to go with the suspension. And my idea is that once we do the suspension, it's suspended through 10/19 of 2013, and it's incumbent upon him, if he wants to have some other outcome than that, either he appeals it or he comes back in front of us with some sort of request that we reconsider this, and he presents some sort of evidence as to why he let it get this far without answering, and that there was some sort of excuse for that that we find to be a valid excuse.
What's going to happen?
Mr. Chairman.
Go ahead, Isaac.
Yeah,
Commissioner Norton.
If I understood the judge's comments correctly, there is no need to put a date, because the statute itself imposes timelines for this individual to comply with, irregardless of what we put out there. And if he doesn't comply, then the statute automatically does what we can't do, which is suspend the license.
So you think it ought to just be that it's suspended indefinitely and not put a date in there? In my motion, is that what you're saying?
And it's automatic. If he doesn't respond based on the statute requirements, then it's automatically suspended. And if the statute requirements exceeds his expiration date, then it'll automatically expire on his expiration date.
My question is that he came into the state from another state as a broker. And I'm not sure what he took test-wise or how he he did this. So his suspension, his license expires, he's suspended, can then he redo whatever it was he did before?
Anytime it's suspended, according to practice, it's flagged, and there is no possibility that, based on our modern system, that he's going to get back in without us knowing about it.
Okay, well, that's my concern, because somehow he got in from another state, whether it was reciprocal or how it was done, as a broker, and I just don't want that to happen again.
We're not recognized
We changed reciprocity.
reciprocity.
Okay.
Of course, we did not have reciprocity with him at that time.
Seemed like it was something
The
different.
point is though if we suspend these, you're going to have to suspend the license today until it's renewal date. You don't need still in business. But at the renewal date, can he reapply, or has he got to satisfy
See,
these
that's what I'm concerned about.
complaints before he can reapply for a license?
That's why I'd
You can
rather,
reapply, but then it's going to be flagged, and if he, when any licensee in Tennessee has a license that's been disciplined, no matter whether it's real estate or medical or whatever, if they reapply and there's discipline pending against their license, it still has to come back to the board or the commission.
Now, I believe that we have the power, even though legal suggests that we have suspension, we have the power to revocate. Mr. Chairman,
Yes.
I want to amend the amendment. And I move that we set the fines for all three complaints, that we assess Mr. Thomas the court cost and all other expenses, and we revoke his license.
I'll second that.
Stop all this.
So you're amending Commissioner McMullen's amendment, which says suspend until October 19, 2003, to the amendment that you are placing with his amendment.
I don't think you can do that. I think you've got to vote on these amendments first,
You can,
and then have a
can't,
motion.
I know you're my parliamentarian, but can you not amend an amendment before you, then we amend the
Not
amendment,
unless-
then we vote on the amendment as amended?
No, not unless Austin withdraws his amendment.
You got, would you just withdraw your motion?
He may not want to.
or we can vote on it.
I'll withdraw my motion to amend.
And Commissioner Alexander, you withdraw your
You can
second.
amend the motion.
Now, what is your amendment to this original motion that was made by Commissioner Northern
Of $1,000.
of $1,000?
My amendment was that we go ahead and set the, if we're going to set any additional penalty, fines for the other two complaints, that we set those those fines for
How
the
much?
other two complaints.
How
What's the
much?
total amount you're talking about?
I don't know, that's why I want somebody to tell me. Is that $1,000 each? Is that what the...
There were 3 complaints filed that were not
So you can sign, I'm going, then my motion, I will put it this way, that the total fine will be $3,000.
Penalty.
Penalty.
The
Total penalty.
will be $3,000, that his license be revocated, and that he be assessed all the expense of this hearing.
Second.
We have an amendment to Commissioner Northern's original amendment, which included just a $1,000 penalty, that $3,000 penalty, revocation, plus the cost associated with this formal hearing today. And we have a second by Commissioner Collins. Discussion on this motion.
Mr. Chairman,
Yes.
I would ask that you divide the question so that we vote individually on each of those 3 penalties.
And I would agree with Commissioner Reese.
Okay. So we'll divide those. We'll vote. We've got a $3,000
We vote on the original
penalty.
motion and then come back and deal with any additional penalty that's being sought.
You got to vote on the amendment first.
We got,
In a second. Well, yes,
Yeah,
I'll
it
say-
was.
yeah, it has, it's been second.
Call for question.
And question has been called. All in favor on the amendment, which includes a $3,000 penalty, revocation of the license, and costs associated with this formal hearing today?
Mr. Chairman,
Yes.
my request is to take those one at a time.
And
Would it be better to just vote
You're going to have to
down?
vote it down.
let's just vote it down.
Down,
Let's
start over.
just vote it down, okay. On the amendment, all in favor say aye. All no, say no.
No.
No. It's 6-2, according to my ears.
Mr. Chairman, I call for the question on the original motion.
Question on the original motion has been called, which is to give a $1,000 penalty on the conclusions of law that we had, that was in the motion, 6213, 312B, 14. All in favor say aye. What? Aye. Point of order.
Point of clarification here. Mr. Northern, is that for each complaint or a total of 1,000?
That's only for that one.
Only for that one.
Okay.
That's for the one. Any other discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
I have a motion.
Okay.
I move that for the other two complaints, that this individual be assessed $2,000 and his license be revocated.
Second.
Mr. Alexander makes a motion that there were 3 complaints this respondent did not respond to, and we have already assessed a $1,000 penalty for one of them. Well, it's actually the conclusions of law, and then are you tying one of the statutes to?
And what I'm doing is on the first motion, you suspended the license until the renewal date.
That was
No.
Withdrew that.
That was withdrawn.
What was the original motion?
The original motion was that Commissioner Northern made was that violation of
What was this, $1,000 fine?
6213 312B be assessed a $1,000 fine. What your motion, I think, is down in 3, where it says 1260-02-02, within 10 days after the date of release, the license shall complete the required administrative measures in retirement.
That's where my point of order came in. There's 3 complaints that he failed to file on,
I'm
and
right.
which is in conclusion
Right.
number 1. And that's what I was asking Commissioner Northern. He's just wanting a total of a $1,000 fine for all 3 complaints not being filed.
Right.
No, Northern just had a
penalty.
$1,000 civil penalty on the first one.
Right.
I'm wrong. I read the wrong law. It is 6213 313 subsection A 2. The accused applicant or licensee shall within 10 days file with the commission the applicant's or licensee's answer to the complaint, a copy of which shall be transmitted to the complaint. I think that is the statute that you're basing your motion on for the other 2 complaints of $1,000 each. It's on the floor right now. And included in that is the revocation and the expense.
Do we not have to do the revocation with number 1? I know, but do we not need to vote on that again, because that's where the law is?
Yeah, that needs to be separated out.
I
We
think
need
the
to vote on
revocation
the
needs to be with
revocation.
number 1 and not with these other 2, because that's what the law is. I mean, that's my
That's
question.
where we can,
Is there a motion and a second on the floor?
yes.
Yeah.
Can I speak to it?
Yes, we're in discussion phase now.
Okay. All we had was evidence of failing to respond to a complaint and failing to send in your paperwork after you were broker released. I don't know what the other facts are. We never heard any evidence of them. To me, to hit the maximum penalty for that seems excessive, because we've got a lot of other things out there that we can only hit somebody for $1,000 for. And so I think, and I don't know if there are other counts that may in the future come before us with respect to this licensee. At the time any of these other things that we didn't hear about today come back, I don't know. But to me, $1,000 fine or civil penalty and suspension for the rest of the term seems about right, since that's the only evidence we have. We don't have evidence that he defrauded anybody or did anything like that. And if that happened, all we could do was hit them for $1,000 and a revocation then. So it seems like we're going to the absolute max when we don't really have egregious facts in front of us. That's my take.
And I want to speak to this motion as well, the chair does. I will vote against your motion to revoke license in this matter because I concur with Commissioner McMullen. This is not testimony, and what we've been asked to rule on this morning does not go to that level. But we've got your motion on the floor. Do you want to take it off the floor, or you want it voted on?
I want to speak to it, too.
Okay, Commissioner Collins.
I usually will vote for suspension instead of revocation, but here's a person who has refused for 9 or 10 months to respond to anyone. I don't think he intends to come back. We're going to help him out with getting him on out of business. I've had people I deal with that won't respond to you in a real estate deal. There's nothing more aggravating. And if they won't respond to anybody, why are we worrying about it? It needs to get out of business.
Okay, we have...
My reasoning for revocation is if you suspend him and then that only handles that for the rest of this licensing period, and we're right back at it again.
Well, you got to pay the penalties, too.
Well, I understand that, but it's just, it was a way I saw he's not going, I'm like Grover's not going to answer the end to it. I don't think you'll hear from him anyway, but just make for sure. But if you don't feel like with that, I vote.
Okay.
Conscience.
We have
Call for the question.
Question's been called on the motion, which is a additional $2,000 penalty. I'm going to have a roll call. $2,000 penalty plus revocation of license, and I'm asking for a roll call, and we're going to start down here with Commissioner Northern.
Yes.
Commissioner, but just come on around the table.
Wait.
We need to.
Let me ask you-
Ms. Maxwell, can you call the roll?
Well, I can call the roll, but was part of Commissioner Alexander's motion that there would also be the expenses would be paid
Yes,
as
that was
well?
included in there also.
So it was a $2,000, this is on just 2 of the complaints, correct, or 2 of the findings, conclusions of law, $2,000 plus revocation of license plus all the costs of this hearing. Is
Yes,
that
ma'am,
correct?
that is correct.
Okay. Northern?
No,
But you're against the amendment, against the motion?
I'm against the motion,
Okay,
and if you want to bifurcate it, take out the revocation, then I'll vote for it.
okay. Collins?
I'm for the motion.
McMullen?
No.
Bifurcated all day.
Haynes?
No.
Stevenson?
No.
Alexander?
Yes. On the motion.
DeChara?
No.
Grease? The motion does not carry. It's
Chairman?
adopted.
Commissioner Alexander.
It's 10 minutes after 11. I suggest that we go over to lunch and we'll finish this after lunch.
Second.
Vote on that, Mr. Chairman.
Let's just finish it.
Let's go ahead and finish. We can see the light at the end of the tunnel. Let's
Can I
get
make a
on.
motion?
Commissioner McMullen.
I move that on the remaining counts, that we impose a civil penalty of a total of $2,000 in addition to the $1,000 that we've already assessed, that we suspend the license for the remainder of the term till it expires on October 19, 2013, and that we assess the respondent with all the costs of this proceeding.
I'll second.
We have a motion by Commissioner McMullen. You have heard it. Additional $2,000 civil penalty, but suspension until October the 19th, 2003, and the cost of this proceeding. And it's been seconded by Commissioner Shaw. Do I hear any discussion on the motion?
Call for the question.
Question has been called. Roll call.
Okay, the motion is for a civil penalty of $2,000 on the remaining counts, suspend the license until 10/19 of 2013, and all costs of the proceeding. Is that correct?
Yes, ma'am, that is correct.
Okay. Alexander,
For the motion.
Collins,
For the motion.
DeChara,
For the motion.
Dees,
Yes.
Haynes,
Yes.
McMullen,
Yes.
Northern,
Yes.
Stevenson.
Yes.
The motion carries.
Can I make a motion?
But it depends on what it is.
I want to make a motion that if he comes back and pays everything, that we require him to retake the broker's exam in Tennessee.
That-
We can do that.
I don't think we can do that, Commissioner Collins, because that is not what is before this commission today.
Mr. Chairman, can I make a motion that we adopt the following policy statement?
Yeah, Commissioner McMullen, yes, it is time now for us to adopt a policy statement in regards to this matter that's been heard before us this morning. Commissioner McMullen.
Mr. Chairman, I move that we make the following policy statement. The requirement of a broker who has been broker released to notify the Tennessee Real Estate Commission as to the broker's status going forward serves a sound policy goal. It ensures that unaffiliated brokers are not practicing unlawfully and maintains contact between the Tennessee Real Estate Commission and the unaffiliated broker. Mr. Thomas violated this requirement, and the penalties imposed are commensurate with that violation. The requirement that a broker timely respond to a complaint ensures that complaints are resolved in a prompt manner and that the resources of the state and parties are used efficiently. Some deadlines must exist and be followed in order for a system of justice to operate. Mr. Thomas failed on multiple occasions to comply with the deadline for responding to complaints. The penalties imposed are commensurate with these violations.
You have heard the policy statement that's been read into the record and placed into motion before this body. Do I hear a second?
Second.
We have a motion and a second. Any discussion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries. And at this time, Judge Safley, I think we have concluded our deliberations with the things that we have been charged with, and I'm turning the proceedings back to you.
All right, if there's no further business, then we'll stand adjourned. Thank you all very much.
We'll adjourn, be back here about 15
Make a motion that Commission
after 1.
Commission for adjournment.
Is Michael, you gonna keep us awake and move right along this afternoon?
Well, I'm actually going to let Mr. Hoffman go after
Is that what we're gonna
Are we on, Mr. McDonald? We're alive?
We gotta get these tablets on and all of this stuff.
Oh, and
Chipper, you're saying Chipper over
Everybody's back from lunch.
again, let me just tell you that there's nothing behind the cover sheets on the iPads, and the documents are not in any order. They wouldn't move last night when I got them downloaded, so you might have 2 or 3 of the same thing on there. So it won't be as easy to navigate as it has been sometimes. But they're all on there.
I found the agenda.
Which we have to.
He found it.
Wait a minute.
We ain't gonna fool that this morning.
Our documents are all marked in blue and say new with a little ribbon on them. And
It's really a cool book.
the ones we're going to do right now are on the second shelf, the first and the third items, I think.
We need to back up and adopt the agenda.
We've already,
No, we hadn't.
I know we hadn't adopted. We can. Let me call this meeting back order. I'm an auctioneer. I like gavels. I'd like to call this commission meeting back into session, and if we want to, we can just back up. The roll has been called enough today. We don't need to call any roll. We know who's here. Invocation, we can dispense with that till next month. Our agenda. Do I hear a motion to approve our agenda?
So moved.
Have a motion by Commissioner DeShaw and seconded by Commissioner Haynes. We approve our agenda. All in favor say aye. Opposed, no. Motion carries. Now, our minutes. We need to approve our minutes from our meeting last month. We have a motion by Commissioner Collins and seconded by Commissioner Grease. We approve our minutes. All in favor say aye. Opposed, no. Minutes are approved. The next thing on our agenda, we have a informal conference, and I would like to call the affiliate broker who wants to, it's Timothy Allen Crane, license number 319481, along with his principal broker, and Mr. Crane and Mr. Tawana. Y'all both are here. If you would come up here and sit at that, get that chair over there and just, oh, there's another one there, I'm sorry. I didn't see that, but if y'all would just sit down right there, and before we go any further, I'm going to ask Ms. Maxwell, our executive director, to go ahead and swear you two in. Ms.
Mr. Tawana, is it Tiwana? Is that what you said? Tiwana. Mr. Tiwana is a principal broker, and he is here today along with his hopeful affiliate broker, Timothy Allen Crane. Mr. Crane lives a straight line distance from Mr. Tawana's office of 84 to 89 miles, and if you get in the car and drive distance, about 114 miles. And so they're here today to request a waiver of the 50-mile rule. The principal broker, Mr. Tiwana, is the principal broker of two firms, both of which are located at 2176 West Street, Suite 200 in Germantown, Tennessee. The affiliate broker, Mr. Crane, resides at 1785 Sycamore Drive in Morris Chapel, Tennessee. The straight line difference between the offices of Kazin Realty and the residence of Crane is between 84 and 89 miles. And as I say, the driving distance is about 114 miles. The rule 1260-2-.01 uses the straight line difference. So it says no principal broker shall engage a licensee who lives more than 50 miles by a straight line calculation. So the straight line calculation, as I say, is between 84 and 89 miles. Mr. Tiwana was first licensed by examination in Michigan as a real estate salesperson on 9/20 of 2001, and his license expired in Michigan on 10/31 of 2003. He was licensed in Tennessee by examination as an affiliate broker on 1/11/2007. As an affiliate broker, he was affiliated with RPS Enterprises, which is doing business as Remax Elite, and by Advent Enterprises. Mr. Tiwana was issued a Tennessee broker license on 4/1 of 2008. His current license expires on 3/31 of 2014, and he has had no formal disciplinary action against him. Mr. Tiwana is the PB of Kazin Realty and Kazin Referral Center. Kazin Realty was first licensed on 2/11 of 2009 with Mr. Tiwana as the principal broker, and its current expiry date is 3/1 of 2013. This firm has 59 affiliated licensees, 44 are affiliates, and 15 are brokers. Kazin Referral Center was first licensed on 2/2 of 2012, and it has one affiliate and 2 brokers, and its current expiry date is 2/1 of 2014. Mr. Crane, the affiliate broker who would like to affiliate with Mr. Tiwana, was first licensed by examination in Florida as a real estate sales associate on 1/5 of 1998. His license in Florida was active from 9/1 of 1998 to 9/30 of 2001, and then again from 8/9 of 2002 to 9/30 of 2007. He did not renew his Florida license after the 9/30/2000 expiry date. Mr. Crane was first licensed in Tennessee on 5/4 of 2009. Mr. Crane took the 90 hours of pre-license education and both the state and national exams at the time he was licensed as an affiliate in Tennessee. Mr. Crane was previously affiliated with List for Less Realty in Savannah, Tennessee. His current expiry date is 5/3 of 2013, and he has no formal disciplinary action against him. Mr. Kazin has written a letter that was sent to the commission members explaining why he believes that he can supervise Mr. Crane at a distance greater than 50 miles from his office. And do you want me to read his letter, or would you like Mr. Tawana just to tell you what his reasons are? What would the commission prefer? Okay. So are you ready? You want Mr. Tawana to give you his reasons why he believes he can supervise?
I mean, he's going to explain what's in that letter.
Correct. He'll explain what's in the letter.
If you would.
Yes, good afternoon. The reason I'm here is to request a waiver to have Mr. Crane with Kaizen Realty. I believe the 50-mile rule, it's not applicable because of the way I conduct my business. Our company focuses and uses latest technology and tools. We use Dropbox. We're a paperless company. Our agents, they do not come to the office to pick up or drop off any paperwork. Everything on their computer, it syncs automatically with our office computer, so the broker has instant access to those files, and we hold regular meetings with our brokers and agents, stay in touch on a day-to-day basis, and communicate about these transactions. We have checklists. Each agent uses a checklist to drop the files in the Dropbox, and we verify those and make sure that the agent is in compliance. As a broker, my job is to make sure that all their files are in order and the transaction, they don't get paid until we have everything in order. Every listing that they input on the MLS, it goes through our transaction coordinator who verifies all the information and files are in order. And if there's anything missing, we call the agent up and, get that added on their computer, which is normally what they do. We have a process in place where every agent that joins goes through orientation, and we teach them how to use the Dropbox. I believe the 50-mile rule is not, it should not apply to us because we don't require Tim to come to the office. He has no need to be at the office for any reason except to pick up a check, and we don't use checks. We do direct deposits. So as a broker, I'm available. If I have to be somewhere to attend a meeting like this today, I showed up, made time for my agents, and if I have to show up again, I will.
Does anybody have any? Well, let's just go ahead and Mr. Crane, let's go ahead and just hear from you as well and talk right into that microphone so we can make sure we have a permanent record of this meeting today.
Yes, sir. What would you like me to say?
Just why you feel like that you being the distance you are, which is not in compliance with our statute, with the rule that we have, why you think that we should grant you a waiver of the 50-mile rule and allow you to put your license with Mr. Tawana.
Okay. Today I'm asking for a waiver, and the reason why is because I too am a little, use the technology tools a little bit more advanced than most regular agents. Sam uses those tools. I like the way he does business. Since I've joined, or since I tried to join with Kazin, I've had a couple online meetings with him where he's gotten on the computer. We've done conference calls, gone over some the Dropbox, gone over the tools that he uses in case I didn't know how to use some of them. I just feel like the ruling, when I brought the piece of papers, it's really by straight line it's about 84 miles, and I know it's a rule, but I just don't feel like that few of a miles over the rule is enough that Sam wouldn't be able to watch what I do as a broker.
Now, specifically, what are you going to be doing, and what kind of business are you going to be conducting?
I'm going to be conducting mostly residential and like farm properties. I get listings, I show property to buyers. I use a paperless transaction. I use, Authentisign on a TAR, and I meet most of my clients at the property. And if they want to, write up a contract, I email it to them. It's a completely paperless. As soon as I email it, they get it. I upload it to Dropbox so Sam has access to it.
You sure can't get to Mark's Chapel.
Hey, Commissioner Alexander, get over it, actually.
No, sir, it's a straight
I
line.
know where Mark's Chapel is.
Yes, sir. Mr. Wendell, yes, sir.
I know you're from
It's a straight line, and I have the map here from Google Maps. If you'd like to see it, it's a straight line. It's 84 miles. Granted, if you drive by road, it's probably about 100, 102, something like that. Which I still, even by road, if I had to be there, I would be here, just like I'm at the meeting today.
Mr. Chair.
Commissioner Northern.
Mr. Tawana, how does your agents receive and respond to correspondence that's mailed to the office?
Mr. Northern, we have several things in place for communication between our agents and the office. Facebook, we heavily use that. We have a private group where all our agents are required to be part of that group. Every single communication goes through that. It goes on their Facebook account and also to their emails. Then on an individual basis, we have a voice over IP set up with all the agents and cloud-based server that we use for communication between the agents.
So if Trex sends information to Mr. Crane, how is it transmitted to him?
If Trex sends the mail to Mr. Crane, it comes to the office. Our assistant, they scan and email a copy to Mr. Crane, and we require read receipt so we know that he has read the email. If it's something important, I would make the call to Mr. Crane, but if it's just a, renewal notice or something, we just scan and email to the agents.
So anything that's addressed to an agent in your office is open with their consent?
Yes, sir. It's part of our independent contractor agreement. All the mail that comes in, it goes into their mailbox, but we ask them for permission if they want us to open and scan and email it to them.
Commissioner Grease.
Thank you, Mr. Chairman. Mr. Tawana, did I say it correctly?
Yes, sir.
So you're basically running a virtual office, is that correct?
Yes, sir.
Okay, I've got 2 or 3 questions about that. As far as earnest money goes, so if Mr. Crane writes an offer is accepted and there's earnest money, what happens to it?
When Mr. Crane gets or will get earnest money, we have accounts with First Tennessee Bank. And we have 2 options for them, either to overnight the checks to the office if they are not within the office limits. Most of the agents, they bring in the checks. We're asking for exception for Mr. Crane because he's not as close to all our other agents. Most of my 59 agents are within my office limits, so they come in and bring the checks. And Mr. Crane would do 2 options, either overnight the checks via FedEx to the office or deposit it into our escrow account at First Tennessee Bank locally with providing us receipt, scanned receipt of the deposit and the check.
Has your office been audited by TREC?
Yes, sir, 3 times.
What do you show?
So we show our transaction system, all our files. We don't have any paper. They're all scanned.
So let's talk about that for a second. So the files that you show, what do you just pull them up on your computer?
Correct, sir.
Can you email those files to the auditor?
Yes, sir.
And do they ever ask for them?
No, sir.
Okay. Just a couple more questions. So Mr. Crane is trying to affiliate with Kaizen, or you're, not the referral, but the,
With the Kaizen Realty.
and I looked at your site yesterday. I noticed his name is on that as if he's an agent now. Is he an agent now?
We submitted our transfer request to Trek along with the letter. I spoke to Patricia Appleton. Ms. Appleton told me to send in the Trek form along with a letter requesting a waiver to do the transfer. He is on the website as an agent because we had to add him to the communication and to our Dropbox. He's not acting as a real estate agent and taking any listings or doing any business until we get an approval or he knows what he's doing from here on.
The Trek 1 form has been signed by his previous agent. You've signed it?
Yes, sir.
Okay. And my last question, if you don't mind, is do you have a sense of how far is too far? I mean, if you make the argument that 84 miles is okay, do you think 100 miles is okay? Do you have a sense of that at all? If it's a virtual office, it shouldn't matter, should it?
I believe it should not matter, but I also believe that if the broker has to take responsibility of their agents and he needs to appear at a commission like this or a formal or informal hearing, he should be within a traveling distance. Memphis and Nashville is 3 hours, and I can easily make that. I think if it was 5-6 hours, I probably would avoid taking such agents to the company. I do have plans to open up branches in Savannah, Tennessee, and that's part of the reason Mr. Crane has applied for a broker's license. So I do plan on, down the road, see a potential if Kaizen can have a branch office in Savannah, and Mr. Crane, if things work out, would run that for us.
Thank you, Mr. Chairman.
Just out of curiosity, what was the motivation, Mr. Crane, to locate with Mr. Tijuana, with Kaizen Realty, when driving from your house to his office, you probably passed 15 real estate companies? He passed
sir.
more than that?
Probably so. The reason why is, one of the reasons is I like the way Sam does business. He's a little bit more technologically advanced than most people are, most brokers are. Another thing that Sam offers is he's got a different kind of commission split that he works with his agents. He's got a new company, and his is more of a volume-based type company, and his split is better than all of those agents that I pass on the way to his office. It's better than all of them.
Anybody else have any questions?
Mr. Tijuana, what do you do to supervise the affiliate brokers that work for your company?
What do I do to supervise them?
Right.
Are you referring to how do I monitor their activities and their...
Sure, I think that would be part of it. And what sort of training or that sort of thing do you provide to them, or how they have questions? How do you deal with that? How do they communicate those to you? Just kind of give me an overview of all of that. I'd appreciate it.
We don't have a training program for the agents. I do not take new real estate licensees into the company. My company business model is set up geared towards independent, experienced agents who've been trained, who have their education, and they just need to keep more money into their pocket. I use webinars. They're pre-recorded most of the times, unless I want to, do a live with a partner, technology partner, that I would do those. That was the training-wise. I don't really do training. I rely on them to have the training from our website. We have an agent portal where they are provided a login, and we monitor their login information, make sure they log in each week and see if there's any updates to our training programs or any office information. is available to them. We also monitor their activities through Dropbox, which is a over-the-cloud, system where all their transaction files reside. So everything that they add in the Dropbox, we automatically get a pop-up on our my system and my assistant system that so-and-so has added a file. So we go in and monitor and checks, make sure all the signatures are there on the contracts and the checklist is complete. And that's pretty much how we monitor their paperwork. As far as their activities outside, they are not allowed to do any advertising unless it's approved by the broker. And we have a communication in place. They email me, and we approve all the artwork. We have an artwork guy that does the artwork to make sure that everything stays uniform, and it's meeting the TREC requirement, real estate requirements. And, I have a very good communication with my agents. I call them on a regular basis to find out what's going on. We have no complaints out of all the 59 affiliates. There's none one in your record. So that tells that we have a good system in place and it's working.
If Mr. Crane places a sign on a piece of property that is not, does not meet TREC guidelines, how are you going to know that?
I don't think I would know that, and I don't think any other broker would know that, because if Crowlike, a broker who have 1,000 listings, I don't think he is going out to look at signs on each property. I would rely upon, Mr. Crane or somebody else, in another agent. They would usually call, or, I'm not sure if that's something any broker would do, to go out and inspect every single sign out there on their listings.
Well, as a commissioner, I can tell you, we get photos of signs that are placed on properties all the time, and you understand that you're going to be responsible for Mr. Crane regardless how far away he is if he places something on a piece of property that's not legal.
Yes, I am.
Mr. Chair.
Commissioner Northern.
Mr. Duane.
Yes, sir.
The two firms that you are currently principal broker for have been in business since, was it 09?
08 was the Kaizen Realty and the Referral Center. I'm not sure, Ms. Maxwell.
Kaizen Realty was first licensed in, Kaizen Referral Center was first licensed on 2/2 of 2012. And then the other firm was licensed in 2007.
The business model that you spoke of, is it applicable to both firms or just one?
Just one. The other is just a referral center where I have people who are going out of business or can't afford to be in real estate, and we try to keep their license active and try to get leads for the office from them to our agents.
Are you aware of any complaints ever being filed against any of the 59 of licensees that are with your company?
As far as I know, I'm not aware of any complaints filed. We do have one complaint filed, I believe, that is with a new affiliate broker that is transferring from First National Realty over to Kaizen, and that was...
Don't give us too much. If this is a new complaint that they haven't reviewed yet,
Okay,
their
I'm
initial
sorry.
stage is anonymous, and you don't need to give away any identifying information.
I'm sorry.
So there's been one complaint that you're aware of?
I have not read the complaint.
I'm sorry.
I have not read the complaint, but I am aware that there was a complaint.
So of the 59 affiliates, as far as you know, there's been only one complaint associated with any of those 59?
Not with my company, with the previous company, with the previous firm.
I simply asked that question because you said you had no training program, and all of your licensees are experienced, and sometimes experienced licensees have complaints filed against them oftentimes have no merit. But just wanted to see how you respond to matters that might lead to a complaint.
Like I said, I don't have any formal training, but I do have training that's we put together. It's in the form of webinars and live webinars with the agents.
Do you ever review any of the contracts that come in, or you said someone else reviewed them?
I
Review any of
I
them?
personally review every single contract before I cut out a check. I'm talking about when it comes into the office. Yes,
The office.
we have 2 transaction coordinators and assistant. They review every single contract that's
No,
added.
I'm asking, do you review any of them? Personally?
Personally, I review every contract before we close, and I have...
Question. When an offer comes in, do you review it?
No, sir.
Okay. I have a little problem with that. I don't mind the long distance, but as principal broker, I have a problem you not reviewing, especially a new agent's contract.
We have three people that are trained to review the contracts, and I pay them to review the contracts because of the amount of transactions we do. I cannot personally review every single one of them. I have trained 3 people whose job is to make sure that they review every single offer, every single contract that comes in a Dropbox. So it is reviewed not directly by me, but indirectly that was trained by me.
Or do you think there's a point where somebody can have too many people under one principal broker? Do you think you need more principal brokers in your company?
Would TREC allow that?
Pardon?
Would TREC allow more than one principal broker in the same
To review
firm?
some of those contracts. You said you couldn't do all of them.
No, I'm able to have thousands of agents in my company, and I have system in place where I can continue to monitor and have people to monitor these transactions. Personally, if you're asking me if I'm going to review every single file that comes in, every offer that comes in, it's impossible. But I have help, and I pay for that help, and they are trained by me, so in TREC's eyes, I'm reviewing those, but these are my people who sit in my office next to me reviewing these files.
I'm not trying to be difficult, but in Georgia they do that a lot. But in Tennessee, it's typically the principal broker, and if they need to be another principal broker, they have another principal broker to review this. So somebody's responsible for the contract that goes.
Well, as a responsible broker, I'm responsible for everyone's actions, and I have to make sure that there's a certain system in place to protect me, the company, and the agent.
Mr. Chairman,
Commissioner Northern.
I move for approval.
Second.
We have a motion and a second to approve this request for waiver of the 50-mile rule for the firm of List for Less Realty in Savannah. No, where's that? Crane. Okay, I'm sorry. I'm looking on the back over here. Crane. And discussion on the motion.
Can I ask one more question, Ms. Maxwell?
Yes.
Yes.
Could you, do you have in your head a little history about why this 50-mile rule is even in place?
I sort of know the history a little bit, but probably Commissioner Alexander is...
If I could. If I could. We're sort of a quandary up here. We're aware in the state of Florida, there's no 50-mile rule. You can have your license and your office can be in Miami, you live in Tallahassee, 350 miles away or whatever it is. There's no 50-mile rule. And we're all aware, sitting up here, that technology has improved and has changed the way this industry works.
Yes, sir.
But the quandary that we are all in is that in our statute, there is a requirement that a licensee live within 50 miles of their office. The reason for that is for supervision. But it's in there. And that's the quandary we are facing and the dilemma that we are in. But it was put there for a principal broker, in a case like you with 59 agents, that you can supervise and manage all of those agents, and the purpose is to protect the public.
Correct.
To protect the 5.5 million people who live in this state. And that's the quandary we're in. And that's the reasoning behind why all of this came to be back when people before we came along put this in effect.
So, Mr. Chairman, the law also allows for a waiver as long as the individual can justify to this commission that there is reason to believe that supervision would be maintained. And in this case, I believe, based on what's been presented, that we don't have an issue with supervision here.
Mr. Alexander.
I think this man will be just as well 120 miles away, which is what he really is. He may be 84 miles where the crow flies. But the way he's going to get to Germantown is double our color that. Now, I sit here and I listen to this broker. And he'd be just as well supervised in Morris Chapel as he's going to be in Germantown. Because he done told you he doesn't have any training program. He does no mentoring. He doesn't do anything. So pass him on through. Let him get in with the other 59 and go on.
So could I go back to my question?
You can go back to any question you want to go back to.
I refer to the question.
The point for me is that he says that he knows that he's responsible. He knows that he's responsible, and if they come back, he comes back.
That's right.
So I was in the process of asking Mr. Maxwell a little history on this. And it's a rule, not a statute.
A rule, not a statute. I'm sorry. I stand corrected.
So is there anything else you'd like to add to what I've just heard?
The rule, it was, I believe it was enacted to make clear that principal brokers do need to supervise their affiliated licensees, and that 50 miles at the time of the implementation of the rule was deemed to be about as far as one could stretch that supervision. And the rule obviously was enacted long before the internet and all the paperless transactions were as prevalent as they are today. And it did allow for property managers to be exempt from that. And as I say, and as was pointed out by us, you could get a waiver. And it is a straight line rule as opposed, because the driving rule, you basically, it looks at the directions I got, you drop down into Mississippi and go back up to Savannah. I don't know if that's really the way you go, but that's the way it's on Google Maps. So it is a driving line, is about 114, but the straight line is 84 to 89 miles.
So how often has this commission considered a request or variance to this 50-mile rule?
If I could answer that question this way.
Go ahead, Mr. Chairman.
I just want to throw one thing in. About 1986, Doug Owens and I sat right there at that table. This was 25 years ago or so. He wanted to put his license with me. And from where he lived, he and I went to auction school together. He was going to put his apprentice license with me, and he was going to work auctions up in the Jonesboro, Fall Branch area toward Kingsport from Knoxville. But I came down, it was 65 miles, and I came down and sat right there and asked for a waiver. And I got shot down unanimously. They turned us down. And we get probably, John, to answer your question, Wendell, how many we get requests we get?
We were getting a rash of them.
Yeah, we were getting a lot more than we're getting here lately.
Now, it was a move a year or two ago to do away with the 50-mile.
Right, we had discussions.
Involved, it made more sense to leave it and make the waivers. that it does do that. This man, he says he's gonna get a broker's license, and when you've got if you're a licensed broker, the 50-mile rule doesn't apply. It's simply for affiliate broker.
Any others?
You don't open up an office in Savannah, you just call the question.
Any other, the question has been called. All in favor of the motion to approve this request, say aye. Aye. Opposed, no. Motion passes unanimously.
Good luck.
Be careful, don't get run over in Morris County.
Up until a couple of years ago, we used to have at least 2 of them.
What's the biggest
Talking to your microphone.
That wasn't for grant.
Yes.
I want to suspend the rules. I want to ask a question. You licensees sitting out there, by show of hands, how many of you feel that the 50-mile rule should continue to be in effect? Raise your hand if you feel that way.
You're setting a precedent right now.
Okay, I got 1, 2, 3, 4. You got 2 hands up. That don't count but 1.
I'm big enough for 2.
Now, how many of you think we should do away with it? Okay, just out of curiosity. Rules are no longer suspended. We'll continue on. Next on our agenda, we have Miss Julie Kropp. Without a doubt, the finest attorney that this commission has ever had.
Uh-oh, you got
I ain't finished. I haven't had at this particular time. We've had a number of good attorneys, but Julie is right up there amongst the top. And
It's on
I'm
the second shelf, it's on the second shelf and on the
Steve, come over and get this thing.
the far right side.
yeah, Wayne Pugh, if you ever watch this, I'm talking about the best one we've got now.
Second shelf.
Robin's
Second
still
shelf.
gonna hurt
Second
that.
shelf,
Yeah, excuse me, you're too
right to
long.
the right.
That's his budget.
Mine does too.
I'm only doing business in the long
Oh,
way.
everybody knows that.
Now fine.
It has to be the long way, yeah. I guess the short way.
Yeah, it has to be the long one.
Okay.
Did you say you couldn't get it? Did you get it?
Oh, I gotta get there first.
I think the audience needs to know we're trying to go paperless, and we're all using our iPads, but they were downloaded by a different person this time, so we're trying to figure out where everything is. But we're getting there.
If you,
Next month, we'll actually have some neighbors with behind the curtain.
That's
Last time
fine.
it was books, this time they're on.
She's getting there.
I'm getting there.
I think it's amazing. I'm proud. Thank you.
if y'all had just somehow been able to,
Thank you.
Miss Maxwell, I was just telling them all, if they had been able to get a hard copy, such as I was able to get, then you'd be okay with the legal report.
Electronically, we did
Yes.
receive it.
Yes.
Didn't print
You didn't print it.
Paperless society.
Bear doesn't know that he received his, and Michelle didn't get hers.
And I didn't get mine, so I haven't read it. I usually read it the night before, but
I've got it.
I received it.
Yes, by fax.
So I hadn't had a chance to look at it.
Electronically.
Oh, you fit right into that office. It just
I was sitting there thinking the same thing.
Get right.
me and you wouldn't last 2 days.
Ms. Kropp, you're in charge.
All right. I'll start by reading the statement at the top of the first page, and I'll try to speak up. Can you hear me back there? Okay.
They don't know if they can hear you. They can't hear you.
I don't-
They can, you
Well-
can hear them.
They can hear.
I'll start by reading the statement on the first page. It says, "Any consent order authorized by the Commission should be signed by respondent and returned within 30 days. If said consent order is not signed and returned within the allotted time, the matter may proceed to a formal hearing." The first and second matters are together. I'll start by reading the first.
Wait just a minute, please.
I'm sorry.
I want to talk to the audience first.
Okay.
Speak up, though, so they can hear you.
Go ahead,
What you're
David.
fixing to hear and see now is the preliminaries that's taking place that happened on the hearing that we had this morning. The hearing we had this morning that complaint came right before this commission, just like these here, or these complaints. We have no idea who they are, it's simply a number. She's going to read them, and we're going to make a decision on the matter that we've been sent, which is in your printed matter or what that she's got. But we'll make a decision from that, and then if you're offered a consent order, if we find you the complaint that needs a consent order, you either sign it or you don't answer it, or you can request a formal hearing. But everybody has an opportunity to be heard. Thank you.
Okay, the first matter is 2011-025-401. This was originally presented at the February 2012 meeting. The complaint alleges that respondent, a licensee, forged their names on a purchase and sale agreement allegedly attempting to purchase their farm. A copy of the sales agreement was provided where the respondent apparently drew a contract for the sale of complainant's farm to a third party. Complainants discovered this when the third party contacted them and said, "Hey, we're the people that just bought your farm." The buyers were supposed to deliver $110,000 to the respondent that week for the purchase price in full. No explanation was given to any of the parties. The respondent submitted no response. The recommendation at that time was a consent order for violation of Tennessee Code Annotated Section 62-13-312B1, making a willful misrepresentation for $1,000. Subsection 2, making a promise to induce a person to enter into a contract for $1,000. Subsection 3, pursuing a course of flagrant misrepresentation for $1,000. Subsection 20, engaging in conduct that is improper, fraudulent, and dishonest dealing for $1,000. And Section 62-13-313A2 for failing to respond to a complaint filed with the Commission for $1,000 for a total civil penalty of $5,000. At that time, the Commission voted to accept the recommendation of legal counsel. The second matter is 2012-005581, and this was presented at the June 2012 meeting. This was a TREC open complaint against the respondent, who is the principal broker, based on the complaint against the respondent's affiliate. The facts as presented to the Commission regarding the affiliate were as follows. I'm not going to reread it, but it's what I just read to you. Respondent 1 is Respondent 2's affiliate. The recommendation at that time was a consent order for $2,000 for failure to exercise adequate supervision over the activities of a licensed affiliate broker in violation of Tennessee Code Annotated Section 62-13-312B15 and failure to respond to a complaint filed with the Commission in violation of Section 62-13-312B14 and Section 62-13-313A2. plus attendance by respondent at a 2-day meeting of the Commission within 180 days of respondent's execution of the consent order. The decision at that time was the Commission voted to accept the recommendation of legal counsel. Since that time, telephone calls between the attorney and Respondent 1 concluded with a promise to sign and pay the consent orders and a statement that Respondent 2 had brain cancer. These calls were in July, and no payments or signed consent orders have been received, despite stating both would be in 2 days' mail on July 30th, 2012. Respondent 1's license expired on May 30th, 2012, and TREC received information indicating that Respondent 1 was arrested for theft in excess of $60,000. Consent orders sent to Respondent 2 came back unclaimed. Respondent 2's firm expired on May 26, 2012. Telephone numbers for both respondents are now disconnected. Respondent 2 has not completed Respondent 2's post-120 hours of education, and Respondent 2's 4th year is up on December 8, 2012, meaning that Respondent 2 could not renew. Were Respondent 2 interested in renewing, Respondent 2 would have to complete the education, pay a civil penalty of $600 for failure to timely complete the education, and address this complaint. A telephone call to the former firm of Respondent 1 revealed that respondents who were married have divorced, and Respondent 2 has moved from the town. An online search did not provide any current information on either respondent except for confirmation of the arrest of Respondent 1. The new recommendation is to both respondents is to close and flag as a result of the current status of the licenses.
You've heard the recommendation of counsel. Anybody have any questions?
Is closing and flagging Respondent 1's file a stiff enough penalty? I mean, you know, we certainly don't want him back out there if he's been convicted of a
Let me explain one thing. Both of these are in the litigation status now, and this
Okay.
is why they're back before you, because in my research and attempting to find these people, I can't. That's why it's back presented before you to review it. And there are no, Respondent 1 has no license, Respondent 2 is, next week will not have a license either.
This has to do with your files. I understand some of the paper files are now being put in boxes and they're getting scanned, and it's going to be electronic, and sounds like a nightmare, actually. So if you flag a file like this, is it going to be electronic now, or is that going to be put in a box and filed somewhere where you can't get to it?
Well, all the files are actually flagged on the RBS system. And so, it's not, it doesn't have an effect on it whether it's scanned or not, or hard copy. We have a note, and there happens to be a manual hold on the ladies expired, but there's a manual hold on these two licenses. That means it can't. But these two licenses wouldn't be able to renew, period. There's a manual hold on them. And we did put a note in the file that's on the screen at the front part of what you open up when you open up RBS on that person's file.
Because all these years I'm picturing a physical
somebody-
file, and now we're really positive we've got all those electronics in.
And like when they're revoked, the hard file actually does have revoked written on it in red letters.
And you will have the same thing on the electronic file.
Correct. And we have that on the electronic file now, but
You might give us a demonstration of that sometime.
Chairman, I move
I don't want to do that. Don't do that.
Second.
we move there.
We have a motion by Commissioner Norman and second by Commissioner Greaves to take a recommendation of council and close and flag. Any discussion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries. Number 3.
Number 3, 2012-013391. This was originally presented last month at the November 2012 meeting. The complaint was opened against Respondent, a principal broker, based on an April 2012 audit of one of the firms at which Respondent was a principal broker. According to the audit report, Respondent was the principal broker of 2 firms at the same location. The audit report indicates that the audited firm was closing within a month. The audit report noted 3 issues. First, the auditor stated the firm sign was not out front because it was waiting to be installed. Second, the auditor noted issues with the escrow account, which included several small overdrafts and had non-escrow payments. The firm had no general account. Finally, the auditor noted that Respondent had written to TREC notifying of a situation where one of Respondent's affiliated brokers was paid a commission from a sale by a related firm which had ongoing negotiation with Respondent's audited firm but no agreement. Respondent submitted a reply stating that in opening the audited firm, they were trying to accomplish a franchise with another firm which did not work out and was the reason for the audited firm deciding to close its doors in May 2012. With regard to the sign issue, Respondent states that a large outdoor sign had been delivered but not yet installed, and a 24 by 24 sign was temporarily in the window. As to the escrow account issue, Respondent states that when Respondent came on with the audited firm, the bookkeeper had the subject account already established. Respondent states that Respondent told the bookkeeper that the account was escrow only. Respondent states that several checks were given to Respondent for use in setting up the firm. Check to Secretary of State, check to TREC, and check to MLS. Respondent states that Respondent was not aware that these checks were given from the escrow account. Respondent states that the overdrafts were due to bank charges of $15 monthly fee. After the firm closed, the account was also closed, and Respondent states that Respondent has learned to be more attentive to the escrow situation. With regard to the final commission issue, Respondent states that Respondent notified TREC of the situation where one of Respondent's affiliated brokers received a commission check from another firm. At the closing, the HUD form listed Respondent's audited firm as the firm to receive the closing check, but it was issued to another firm which Respondent's audited firm was, at the time, attempting to do a franchise with, which later fell through. And the principal broker of the other firm deposited the closing check and issued it to Respondent's affiliated licensee. The recommendation at that time was a letter of warning regarding Rule 1260-02-.091, which states that each broker shall maintain a separate escrow account for the purpose of holding any funds which may be received as deposits, earnest money, etc., and subsection 3, which states that brokers are responsible at all times for deposits and earnest money. The Commission voted at that time to defer the matter to allow Commissioner DeChara to review the file and report at the December meeting. So the new recommendation is to have Commissioner DeChara discuss.
This file was kind of a convoluted mess when you dug down at it and looked at it. However, the person that the complaint was originally filed on, I believe, did everything that they could to get the accounting for the escrow account. I think there was some money put into the escrow account that came from the owner, and the broker that this was filed against didn't actually have access to that original escrow account. Somebody else had set it up before this broker came on board. And I believe that this broker did everything they could to try to remedy the problem. However, when we looked at the file, and you look at the fact that another broker paid one of the original broker's licensees for a closing, it does appear that there needs to be a complaint opened against the affiliate and the other broker.
And I've conveyed, when we spoke, I conveyed that to Ms. Maxwell for them to handle. But as far as this respondent who this was opened against, we looked at, it appeared there was one client transaction, and that client's money was given back to them. It doesn't appear that anybody else's money was misused to pay. It doesn't appear that anybody's money was not accounted for that belonged to clients. So it's your recommendation if you want to go with the original letter, or if you think that that's not appropriate, whatever your recommendation is.
Well, my recommendation is to this original broker, the letter of warning with opening files against the other principal broker and affiliate.
Which is council's recommendation. Is that right?
We conferred on
Mr. Chairman, I'll move we accept council's recommendation.
Motion been made by Commissioner Drees and seconded by Commissioner McMullen. We accept council's recommendation. Any further discussion? All in favor say aye. Aye. Opposed, no. Motion carries. We're gonna listen to one more complaint, and then we're gonna take about a 10-minute break.
Okay. Number 4, 2012-016-321. Complainant was the owner of a property who contracted with respondent, principal broker, to manage complainant's property. Complainant alleges bad management services by respondent, included but not limited to failing to timely pay complainant rent money until several days past the date specified within the management agreement, leasing the property to a tenant prior to discussing the move-in date with complainant, leaving responsibility to conduct minor repairs to complainant, and failing to return the tenant's security deposit after complainant terminated the management agreement with respondent and asked that respondent forward the security deposit to another management company retained by complainant. Respondent submitted a response disputing complainant's allegations. First, respondent states that complainant agreed to do certain repairs to get the property rented, which were never done, and respondent was not permitted to make certain repairs. Additionally, respondent states that complainant was pleased that the tenant moved in early, and respondent signed the lease with the tenant after informing complainant of the arrangement. As to the rent payments, respondent states that there was a banking mistake for the tenant, which resulted in the tenant having to write a second check to make the funds good, which resulted in withholding payment to complainant until respondent's office could verify that the funds were good. Finally, when complainant terminated the management agreement, respondent felt respondent was entitled to a termination fee in light of the services provided. Complainant's issues with the repairs, the payment of rent several days after the time specified in the contract, and the tenant's move-in date are disputed by respondent and do not appear to be clearly resolved by the management agreement, which is poorly drafted. It appears that there is possibility of future litigation between the parties based on complainant's termination of the management agreement and fees which respondent claims are due to respondent based on the termination. However, complainant terminated respondent's property management services and requested a release of the tenant's security deposit in writing in November 2011. Respondent did not release the tenant's security deposit to complainant until November 2012 after this complaint was filed. The recommendation is a consent order for failing within a reasonable time to account for or to remit any monies coming into the licensee's possession that belong to others in violation of Tennessee Code Annotated Section 62-13-312B5 with a civil penalty of $500 plus attendance by respondent at one entire meeting of the Commission within 180 days of respondent's execution of the consent order.
Move to adopt council's recommendation.
Second.
We have a motion by Commissioner McMullen to accept council's recommendation and seconded by Commissioner Northern. Any discussion on the motion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries. And I also want for the record to note that the complaint that Commissioner DeSharo, which happens to be complaint 2012013391, let the record show that Commissioner DeSharo abstained from the voting in that matter. Let's take a 10-minute break. Come back in 10 minutes. Hint, hint.
Y'all need like the lights like we do with the theater.
Yep. Commissioner McMullen and Commissioner Grease are attending to some business via the telephone. We have a quorum, so we're not. Commissioner Alexander. Love you, bye. Back in the number 5, Ms. Crock.
Number 5, 2012-016-821. Respondent and affiliate broker was the listing broker for a property purchased by complainant. Complainant wished to construct a wooden outbuilding and fence on the property which conflicted with the restrictive covenants for the subdivision. Therefore, one of the contingencies for the purchase was to resolve this restriction. Complainant states that complainant was told that if complainant used the same closing company, respondent would have an attorney with the closing company draft a letter and respondent would obtain the signatures of 50% of the owners in the subdivision to effectively override the restriction. This was done, and complainant states that respondent did not obtain enough signatures by closing to override the restriction. Further, complainant states that respondent is familiar with the subdivision and sellers and would have had knowledge of the easements and setbacks which respondent did not disclose to complainant's broker. Additionally, complainant alleges the number of issues with the home were not listed on the seller's disclosure forms, such as some of the windows on the home were damaged with condensation and had other characteristics indicating defectiveness, as well as other matters including a leaky shower and toilet and problems with the air conditioner. Complainant states that these defects were not listed in the disclosure forms, and respondent knew of this based on respondent's familiarity with the home and sellers, and respondent should have been sure that these matters were disclosed to complainant. Respondent submitted a reply denying that respondent told complainant that complainant would need to use the same closing company in order to get the letter, but instead only suggested that the same closing company use the same closing company to avoid a split closing. Respondent states although it was not respondent's responsibility, that when complainant's broker notified respondent of the restrictions and the process by which the restrictions could be overridden, respondent agreed to assist complainant's broker in obtaining the signatures. Respondent states that 8 signatures were obtained out of the 19 homes in the subdivision due to the fact that one home was foreclosed and bank-owned and the other was the subject property. Respondent states that these 2 properties were not counted on the total due to respondent and complainant's brokers believe that these properties should be excluded. Because there is no HOA, respondent sought guidance and was directed that respondent should ask an attorney to draft a letter regarding the necessary process for an override, and respondent and complainant's broker obtained 8 signatures. Later, the sellers of the property added their names and complainant was able to construct the wooden outbuilding and fence. Respondent denies knowledge of any of the easements and setbacks and states that complainant signed a disclaimer advising the services of a licensed professional for those issues. As to the disclosure issues, respondent states that respondent did not assist in completing the seller's disclosure and respondent is not a home inspector who could have known of the issues, and complainant hired an inspector who completed a report on the home. Based on the documentation contained within the file, there does not appear to be a violation of TREC statutes and/or rules by respondent, and therefore the recommendation is to dismiss.
Julie, from looking at the file, are you pretty confident that the respondent didn't have any knowledge of any of the damages that were not on the disclosure?
Based on the documents that I reviewed, it appears to be somewhat of a he said, she said. I mean, that I didn't see any documentation proving that there was knowledge and willful failure to disclose on the part of the respondent here.
You've heard your counsel's recommendation. Are there any additional questions of Ms. Crock before we Entertain a motion.
I move to accept council's recommendation.
Commissioner Haynes makes a motion, we accept council's recommendation, and Commissioner Collins seconds the motion. Any further comments or discussion on this complaint? Hearing none, all in favor say aye. Aye. Opposed, no. Number 6.
Number 6, 2012-017-171. Complainant was the owner of a property which was listed for sale. After entering into a purchase and sale agreement with a potential buyer who was represented by respondent and who complainant later found out was respondent's nephew, for the purchase of complainant's property, complainant moved out of the property, but the closing was delayed several times due to financing difficulties on behalf of the potential buyer. During that time, complainant visited the property and found the lockbox and for sale sign missing and evidence that someone had entered the property and begun renovating it. Complainant then learned that respondent's nephew had been admitted to the property with respondent to begin doing work that he wanted done prior to move-in because respondent thought the closing was going to take place in a couple days and respondent felt sorry for him. Complainant instructed that the property be put back on the market, that respondent pay for repainting of several rooms which had been altered, that respondent have the locks rekeyed, and that respondent and respondent's nephew would not be allowed back into the property. Complainant went to the property on the following day to find that the locks had been rekeyed and complainant could not enter. Complainant was told that respondent had the locks rekeyed and had the only copy and planned to use the key to let professional painters in over the weekend. When complainant visited the property on the date that the painters were to be working, complainant found respondent in the property who was there repainting the designated rooms. Respondent submitted a response stating that the property closed and respondent's nephew, the potential purchaser referenced above, purchased the subject property approximately 1 week after the complainant sent this complaint to TREC. Respondent states that this was due to financing difficulties. After the walkthrough, a few days prior to the scheduled closing, respondent states that respondent was given permission by complainant's broker's office assistant to remove the signing lockbox and bring to the closing. After the walkthrough, respondent states that respondent was attempting to remove the lockbox and respondent's nephew offered to assist by holding the items in respondent's hand. One of the items was the key. After removing the sign, respondent and respondent's nephew parted ways, and respondent claims that respondent did not realize that respondent did not get all the keys back. Respondent states that respondent did not realize respondent's nephew had been in the house until notified by complainant's broker. Respondent addressed the issue with respondent's nephew, who respondent states was embarrassed and remorseful and did not realize he should not have accessed the property. And respondent states that respondent tried to cover for respondent's nephew's actions by telling complainant's broker that respondent had assisted in making the repairs. Respondent states that respondent had the locks rekeyed as directed but could not find a professional painter to paint the property immediately as complainant directed, so respondent, who is a professional painter, decided to do the painting work personally. Complainant apologized for the misunderstanding and stated that nothing of this nature would ever happen again, but reiterated that the property eventually closed. The recommendation is a consent order for failing to diligently exercise reasonable skill and care in providing services to all parties to the transaction and failing to provide services to each party to the transaction with honesty and good faith in violation of Tennessee Code Annotated Section 62-13-312B14 and 62-13-401, subsections 1 and 4, and acting on behalf of an individual in which respondent had a personal interest without prior disclosure of the interest and timely written consent of all parties to the transaction in violation of Tennessee Code Annotated Section 62-13-4037A with a civil penalty of $1,000, I should say $1,000, I'm short of zero, plus attendance by respondent at one entire meeting of the commission within 180 days of respondent's execution of the consent order.
Motion to accept.
Second.
Have a motion by Commissioner Collins and second by Commissioner DeShaw to accept council's recommendation. Is there any discussion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries. Number 7.
Number 7, 2012-017721. Complainant was the unrepresented potential buyer of a new property under construction which was listed by respondent, an affiliate broker. Complainant was pre-qualified and complainant made an offer. After entering into a sales contract with the builder, complainant began selecting finishes for the unfinished property. At that point, complainant learned there was an additional $500 upgrade fee for stainless steel appliances, which complainant was not aware of when complainant made the offer. Complainant opted to write a check for the upgrade fee since the offer had already been submitted to the mortgage company. Shortly before closing, the mortgage company informed complainant that complainant would have to pay a tax bill owed to the IRS before closing, which the complainant could not do. Complainant met with the respondent and the builder seller to try to work out a situation to make the sale go forward, but ultimately the sale did not go through. Complainant states the complainant attempted to contact respondent multiple times by phone and text about receiving a return of the earnest money and upgrade fee. Later, complainant states that respondent provided complainant with documents for a request of a return of complainant's earnest money and upgrade fee, which complainant signed and returned. Complainant states that complainant received a return of the earnest money, but as of the date of the complaint, the complainant had not received the upgrade fee. Respondent submitted a reply stating that respondent prepared the earnest money and contract cancellation release form, which complainant signed and returned. Shortly after, respondent states that respondent left employment with the firm and moved elsewhere. Respondent states that records indicate that the earnest money deposit was returned, but complainant is unsure how the return of the upgrade fee was handled by the builder seller. Respondent states that complainant chose to pay for the appliance upgrade outside of closing rather than including it in the mortgage. Respondent states that respondent worked very hard to get the builder seller and complainant to meet to resolve the issue when the sale fell through, but complainant would not do so. Based on the information contained within the file, it does not appear that respondent's actions constitute violations of TREC's laws and/or rules, but appear to be issues between complainant and the builder seller, and therefore the recommendation is to dismiss.
Second.
A motion to dismiss by Commissioner Collins and seconded by Commissioner Northern. Any discussion? All in favor say aye. Opposed, no. Motion carries. Number 8.
Number 8, 2012-017-861. Complainant is the owner of a property which has been managed by respondent unlicensed since 2010 when the parties entered into a property management contract. After complainant did not receive the rent payments from respondent for several months in 2012, complainant discovered that respondent had collected the rents from the tenant but had not forwarded complainant's portion. Complainant terminated respondent's services and filed this complaint after learning that respondent was not licensed. Respondent submitted a response stating that respondent was unaware that respondent needed a license to perform these property management services. Respondent states that after receiving the complaint, respondent ceased managing property for others and now only manages a few of respondent's own properties. An auditor visited respondent's address, which the auditor discovered was the address for a mail store where respondent owns a mailbox. Information obtained from respondent's website advertises 5 properties for rent, which appear to be owned by respondent, except for one property which states it is owned by a business, but the business address is same as respondent's address. However, respondent's website advertises property management services for a fee, which include but are not limited to management, rent collection, property showings, advertising, and applicant screening. The recommendation is a consent order for $500 for unlicensed activity in violation of Tennessee Code Annotated Section 62-13-102 4A and B, which define the broker activities. Section 62-13-103 and 62-13-301. Said order to also include an order to cease and desist all unlicensed activity.
And how do we monitor this person? I know.
Motion to accept council's recommendation.
Second.
Commissioner DeShaw makes a motion to accept council recommendation, and Commissioner McMullen seconds the motion. Any discussion? Further?
I'd like to add to it that we send a copy of this to the district attorney in whatever county this happened in, our actions.
Would you accept that as a friendly amendment to your motion to accept council's recommendation?
I will.
You will? Commissioner?
Yes.
Okay. So, we'll send a letter to the district attorney in the county in which this infraction occurred. Any other questions or comments? Hearing none, all in favor say aye. Opposed, no. Motion carries.
Number 9, 2012-01-7731. The complaint alleges that respondent, principal broker, utilized a professional designation on respondent's website. Complainant states that respondent is not a member of this professional network. Respondent submitted a reply stating that respondent completed all the requirements to be awarded the designation and was a member of the organization in the past. However, respondent states that respondent is not currently an active member purely because the past dues have not been paid. Due to the fact that respondent's license has been revoked, it is recommended that this matter be closed and flagged. Therefore, the recommendation is to close and flag.
Make a motion, we approve council's recommendation.
Second. Quick question.
Commissioner, let me go ahead and get this motion on the floor. Commissioner DeShaw makes a motion, we accept council's recommendation, and Commissioner McMullen seconds it. Now Commissioner Grease for discussion.
Was this complaint filed by an organization or an individual?
An individual.
Okay. Can you tell us which designation it was, or is that any of our business?
Just an individual.
Okay, not an
It's-
organization.
No, the
Okay.
complainant is an individual member of the public.
Okay.
Presumably, I'm not familiar with it, but no, not a member of the, what is it called? The organization that awards this
Right.
designation, it does not appear to be anyone affiliated
Okay.
with that.
Any other comments or discussion? Hearing none, all in favor say aye. Opposed, no. Motion carries. Number 10.
10-2012-018331. Complainant, a resident of another state, was contacted by an individual who represented that he was with a company, also out of state, which wanted to acquire and resell complainant's timeshare, which is located in Mexico, to a third party. Complainant was informed that the transaction would be handled through a company in Tennessee. Soon after, complainant was contacted by respondent, an individual who claimed to be connected with the Tennessee company. Respondent told complainant that complainant would have to sign a power of attorney release for the resale and pay several $1,000s up front, which would serve as taxes paid to Mexico so documents could be obtained to finalize the sale, which complainant refused to do. Respondent also sent complainant a document claiming it was a copy of the company's license, which is a fake Trek license. Complainant, realizing this was a scam, filed a complaint. A copy of the complaint was sent to respondent via certified mail at the address provided on correspondence from the respondent, which was returned as undeliverable. Based on information obtained from the Better Business Bureau, the address provided is a vacant building. The recommendation is to refer this to the district attorney's office and close it.
Motion to approve council's recommendation.
Second.
Motion to approve council recommendation is made by Commissioner DeShaw and seconded by Commissioner McMullen. Any other comments or questions concerning this complaint? If not, all in favor say aye. Opposed, no. Motion carries.
Number 11, 2012-021771. In 1977, complainant purchased a lot in a development run by a resort company. The resort has since changed its name and is now known as Respondent Timeshare Registration. Complainant states that complainant was promised a number of things, which complainant states were lies, included but not limited to that the lot would increase in value in 2 years, that the club dues would pay several of the utilities, that a marina would be put in, and the developer would purchase the lot back if complainant became dissatisfied. After 10 years of paying club dues, there were still no improvements to the lot, no roads, no water, no sewer. Complainant surrendered the lot back to the developer for free in 2001 because complainant no longer wished to pay dues. Complainant did not provide any of the original purchase agreements, but just provided copies of complainant's letters and complaints to other agencies. It appears complainant is filed with a number of agencies. A reply was submitted on behalf of respondent stating that the resort, which respondent was formerly known, was sold undeveloped lots in the 1970s and 80s, and all lot sizes utilized disclosure documents filed with HUD. Respondent denies wrongdoing, stating the documents did not promote the sale of lots based on investment potential or represented that the lots would be developed. However, respondent noted that agreements were entered with the Tennessee State Agency and HUD to resolve the complaints of this nature with consumers, which provided categories for relief options for eligible consumers who had filed complaints. And respondent states that complainant did not file complaints prior to the necessary cutoff date, which was 5 to 6 years ago, and therefore complainant was not eligible for relief under those settlement agreements. There's a lack of documentation regarding the purchase and/or alleged representations made by respondent other than the complaint and complainant's letters to other agencies. However, based on the information provided by respondent and contained within the file, complainant's allegations took place well outside of the 2-year statute of limitations, and therefore the recommendation is to dismiss.
Move to dismiss.
Second.
Motion made by Commissioner Northern to dismiss and seconded by Commissioner Haynes. It sounds like some of the developments I'm familiar with up in East Tennessee. Any other questions or comments? Hearing none, all in favor say aye. Opposed, no. Motion carries.
12, 2012-019031. Complaint opened by Trek against respondent firm based on respondent's failure to satisfy an agreed citation sent to respondent as a result of a Trek auditor's report regarding respondent's accounts. The auditor's report noted an issue with the earnest money disbursement for a property, wherein the auditor stated the sales contract and the closing statement conflicted as to the amount and holder of the earnest money. Respondent sent a response disputing any error and stating that the auditor did not consider additional documents consisting of counteroffers and the purchase and sale agreement, which reconciled with the earnest money amount and closing statement, in which which was dispersed according to the contract and amendments. Based on the documentation provided by respondent, it appears that the earnest money amount stated in the contract was dispersed at closing, with all parties receiving the money which they were entitled at closing. Based on the information contained within the file, there does not appear to be a violation of TREC statutes and/or rules by respondent, and therefore the recommendation is to dismiss.
Move to dismiss. Second. I have a question.
Commissioner Northern makes a motion that we take council's recommendation to dismiss, and it was seconded by Commissioner Haynes. Now, discussion.
The complaint was filed by TREC based on the actions of a TREC employee. The response came after the complaint?
No, the response, correct me if I'm wrong, the agreed citation was sent out as a result of the audit report. The
agreed citation came after the original complaint?
No, the agreed
There was
citation.
no complaint?
The agreed citation was sent to the respondent based on the audit report. For some issues, the commission has granted staff the authority to send out these agreed citations based on certain issues. So an agreed citation was sent to this respondent. When respondents satisfy and pay agreed citations, they're closed. They don't ever rise to the level of complaints. Instead of satisfying the agreed citation, this respondent responded and said, I don't agree to this agreed citation, here's why. The process is then, if the agreed citations are not satisfied, they're then opened as complaints, which is why it was being presented, because the respondent disputed the agreed citation which was sent. Am I?
But there was no basis for the complaint to start with.
It was based on the audit, right?
It was based on audit
An
and
incomplete audit.
The agreed citations are given numbers that, like complaint numbers, so they're given a number. And if the person doesn't respond within, doesn't pay or respond to the citation within the time given, then it goes up to the legal, goes down actually to the legal department, and it's opened as a complaint at that time. But it's assigned a number when it first is opened as a citation. So by the time the process got that far along, it had already gone upstairs as a complaint. You know, like, and once it's upstairs, it has to be, and once the legal department has it, it has to be presented to the commission for a decision.
My concern is that this individual who did nothing wrong now has a flag on his file because we didn't follow through.
Well, he doesn't have he doesn't have like a flag, like this, it's not like flagged on his file. It shows that if you go into the complaint part of RBS, it will show that this was dismissed, just like every other complaint that's dismissed.
I can understand that being the case if a member of the public or another licensee filed a complaint, and we have to follow through to get to the point of dismissal. But when we ourselves are filing a complaint, I think that's wrong. That this individual has to, well, first of all, they defended it and were justified, but there shouldn't be any reference to it in that person's file.
Right. I agree with you. Because of the public records, nothing is taken off of the file, so that even if there was a spurious complaint filed 15 years ago, it remains on your file, which is.
Well, maybe we need to reverse the process so that before it gets to that point, that individual has a right to defend themselves so that there is not something in their file that should not have been there to begin with.
Well, I think that would be a great thing for the commission to discuss, so that you don't have that showing up on your file.
This never came before this commission, though, did it? Did this an auditor decision and then found it and then find this?
Well, what the auditors do is, they'll go out and they'll audit a firm, and they mark whether there's a citation or an auditor concern, a violation or an auditor concern on the inspection sheet, and then they submit whatever documentation that they got that would support the decision, what they wrote on the inspection sheet. And then I'll look at every one of those that has a violation or an auditor concern. And if what they submitted at the time supports that, then the commission granted the administration the authority to open citations up to certain amounts, and there are specified dollar amounts for certain violations. And so then a citation would be issued to the person. And the citations are now given numbers so that they can be tracked just like complaints. And so they're given a number which is a complaint number. I mean, it's the same number, the same number that's given, that you see right there. And so then if that citation is not, if they don't answer the citation, or if they don't, in a timely fashion, or they don't pay it, then it goes to upstairs to the complaints within the time, because we have that 180-day span, and there's certain guidelines that the complaint has to follow. And so then it would go upstairs to the legal department. And then, as I say, once it's in the legal department, it has to be presented to the commission for a decision, like we can no longer administratively close something. But I mean, it does stay on people's file, just, and that, even though it says dismissed, and then if you ask for a certificate of licensure, things that are dismissed, they are not listed as disciplinary action. So that if someone were to write you and ask for a license history.
May I have your attention? We're about to refill the sprinkler system on the first floor. We'll make an announcement when we are done filling the first floor. Please disregard all alarms for the next few minutes. You're sitting right under one.
But it sounds like, why did
The process is reversed in this situation, and it should not have been.
why was the citation or complaint filed when maybe it would have been better just to talk to the respondent about the additional documentation first? Is that kind of what you're saying?
Well, when the auditor, like when the auditor comes back, he comes back with what he gets from the firm that supports or doesn't support what he found. And in this situation, what he brought back was a contract that, supported what he said, and the person didn't say anything at that time. So that, the auditor either sits down with the principal broker or sits down with the person who's in charge of the books and goes over the audit with them. And at that point, they can, some people, as soon as the auditor walks out the door, email me and say, look, this is, I've got some other information, I got to go find it from someone else, or, whatever their situation is. And in this instance, it didn't happen.
Wasn't documented, it didn't work in the contract, the addendum to the contract was in the file, I bet you.
Well,
and then they went and found it and put it in there.
Well, I mean, I don't, and so, that might have happened as well. I don't think it probably was.
But the respondent had an opportunity to possibly provide these documents at that time, and I guess didn't.
Right, or they'll get a copy of the audit when you leave. When the auditor leaves, he leaves a copy, and so that even if the principal broker wasn't there, when he sees it, he could say, oh, whoa, wait a minute. And as I say, a lot of them, as soon as they walk out the door, they email and say, whoa, I've got this information, I've got to get it from the other broker, or, I've got it in another file, and then they'll send it in immediately. And then a citation's not open.
I'd be watching.
Any other questions or comments? Question has been called. All in favor say aye. Aye. Opposed, no. Motion carries. Do you know what this means, Commissioner Haynes? That means you're in charge.
Well, you're getting out just because the rain's coming.
Well, he's not leaving.
No, he's sticking his foot up. I'm getting ready to get underneath the table. So we got 13, 14.
Okay. 13, 14, and 15. 2012-019-531, 2012-019-532, and 2012-019-551. The complainants were timeshare owners who attended an update presentation in 2008 with their daughter and son-in-law given by respondents. Respondent 1 is a timeshare salesperson, Respondent 2 is timeshare registration, Respondent 3 is Respondent 1's principal broker. At that time, complainants purchased more points and combined existing points with their daughter and son-in-law to create one contract so they could combine the points with complainants' timeshare from another resort through an exchange program to acquire gold status and use their points each year. A few months later, complainants state that they realized that the exchange program would allow gold status was no longer available. Complainants state they were misled at the 2008 presentation. Therefore, complainants made a subsequent purchase in 2010 at another resort to obtain gold status. Respondents submitted a response disputing any misrepresentation but offering to release complainants from their memberships. Respondent denied any misrepresentations regarding the exchange program at the 2008 sale and state that the terms of the program were explained and outlined in activation and disclosure statements which were available to complainants at the presentation. The documentation within the file does not appear appear to substantiate a misrepresentation by respondents. However, it appears that this transaction took place well outside of the 2-year statute of limitations, and the recommendation is to dismiss.
Got a motion?
Second.
Second by Commissioner DeCharo. The motion was made by McMullen. Discussion? All in favor?
Aye.
16-2012-019791. Complainant is the owner-seller of a commercial building who was contacted by a potential buyer who met with complainant regarding buying the property. Complainant and the potential buyer met with respondent, principal broker, regarding assistance with a purchase and sale contract if complainant, who was unrepresented at that time, and the potential buyer could come to an agreement. Complainant, having numerous interested potential buyers, then signed a listing agreement with respondent for the property. Complainant states that the listing agreement included instructions that the initial potential buyer would be excluded since complainant and that buyer had been in negotiations prior to the listing agreement. However, complainant alleges that respondent did not provide complainant with a copy of the signed agreement at that time. Later, complainant and the initial potential buyer came to an agreement on the purchase of the building. At that time, complainant states that complainant first received a copy of the listing agreement, which complainant states was not the same agreement that complainant originally signed because, among other matters, the agreement in complainant's possession did not exclude the initial potential buyer. Soon after, complainant and respondent became involved in civil proceedings regarding the commission issue. Respondent submitted a response with court documents stating that this matter involves a commission dispute, which is the subject of pending litigation between the parties. Court documents indicate that the pending litigation does indeed involve a commission dispute described in the complaint. Subsequent documentation submitted by the parties indicates that the parties have settled their civil commission dispute, and the documentation contained within the file does not appear to evidence a violation on the part of respondent with regard to the listing agreement. Therefore, the recommendation is to dismiss.
Motion to approve council's recommendation.
Second that motion.
Commissioner Charo made a motion, seconded by Commissioner Stevenson. Any discussion? All in favor? Aye.
Number 17, 2012-020591, complaint opened by Trek against respondent, a principal broker, based on respondent's failure to satisfy an agreed citation sent to respondent. As a result of an auditor's report which indicated an auditor concern regarding the amount of time taken in the transaction before earnest money was disbursed back to the buyer, respondent was sent an agreed citation which included a civil penalty for an escrow account violation. And because respondent had not signed and returned said agreed citation, the matter was opened and legal as a complaint. Soon after the matter was open and legal, respondent submitted the executed agreed citation and paid the civil penalty included therein, and therefore the recommendation is to dismiss.
Motion. Good to dismiss.
Second.
Motion to dismiss by Commissioner Grease, second by Commissioner Northern. Any discussion? All in favor?
Aye.
Opposed? Okay.
18-2012-021821. Complainants live out of state and are owners of a timeshare in Mexico who were contacted by representatives from respondent, an unlicensed entity with an alleged address in Tennessee, claiming to represent a company who wanted to rent 5 weeks of complainant's timeshare for a convention the company was holding. Respondent's representatives told complainant that complainants would need to wire money to an escrow account.
Motion to accept council's recommendation on this one.
Got a motion from Commissioner Collins and a second by Commissioner Northern. Any discussion?
I just have a question.
Okay.
Is this in any way related to the file?
Separate people, it appears.
Okay.
We wouldn't have any,
We can't find them to get any kind of service on them. We don't even know in these cases of these scams, they have addresses that say they're in Tennessee, but we don't have any proof that anybody was ever actually in Tennessee doing it. And with our resources, it would be very difficult to locate these people when they could have gotten a 615 telephone number and had it disconnected, and they were never in our state. So that's the reason
An
why.
emergency has been reported in this building. Please cease operations and leave the building utilizing the nearest...
That's the reason for referring them to the district attorney. Hopefully enough people will do that to where the district attorney can use their resources to take the appropriate action against these scammers.
Emergency.
Okay, all in favor?
Aye.
Opposed? 19?
19-2012-022401, This is a TREC open complaint based on respondent's principal broker's failure to comply with the terms of a final order of the commission. Specifically, respondent failed to pay the required civil penalty, failed to complete the specified continuing education, and failed to pay half of the court cost, all included as provisions of the final order. The respondent submitted no response to this complaint. The recommendation is a consent order for voluntary surrender of respondent's license for violating the terms of any lawful order entered by the commission in violation of Tennessee Code Annotated Section 62-13-312B14 and failing to respond to a complaint filed with the commission in violation of Tennessee Code Annotated 62-13-312B14 and
Have
Section...
your attention, please. We are finished working on the sprinkler system on the first floor. There'll be no more alarms for the rest of the day. Thank you.
and Section 62-13-313A2.
We can't get them to respond to complaints, but we're going to get them to voluntarily surrender their life.
There are two matters that are already authorized for a formal hearing before the commission. It's my indication from the litigator that this individual has an attorney and is planning to go forward with that hearing, and we're planning to handle all of these matters at once at that
Why
point.
not handle this one too?
That we have to go through the consent order stage first, and so that's why this is the offer, and then presumably this person will not elect to accept that, at which point this matter will be handled with the other two matters at formal hearing before you all.
Motion to accept.
Second.
Commissioner Collins made a motion, Commissioner Northern seconded. Any discussion? All in favor? Aye. Opposed? Motion passes.
Madam Chairman,
Looks like this is the end. Yes, sir.
could I ask, just for my education, so last month we revoked a license. That person's license shows revoked on the TREC website. And then on the company line, it says problem. That's how it's coded, I guess. And tell me what that means.
The individual's license was revoked last month. The firm licenses were not revoked, along with the person's license. So the principal broker, so each of those firms has no principal broker at this point because their principal broker has their license revoked. So we can't just arbitrarily revoke a firm license or close a firm without some instruction either from the commission or from the principal broker. So the firms are in problem status because they have no principal broker at this point in time.
How can they operate? They can't, by default, they have to close if they don't have a principal broker?
They have, well, they have no, those firms should be closed, but we can't close them. We can't close them just on our own volition. It has to, as I say, either be done from an order from the commission or the person has to do it themselves until once they expire by their own terms. In the instance of the person who was revoked last month, the legal department sent them a letter already advising them that they were to cease and desist immediately. And on top of the final order which the person received, they likewise got another letter from the legal department advising them that they need to cease and desist immediately from the practice of real estate.
Could they go out and hire another principal broker?
Well, that's what we were trying to keep from happening. That's what I think the person might want to do. And
So should we have revoked both the firm and the person?
I don't know.
The firm license is not before, that the firm is not before this group.
So you have to bring us the firm license and,
First, the complaint has to be opened against the firm itself,
To take action.
to take action against the
At a
firm.
formal hearing.
And the problem is the firm is the person. And
That's right.
You
Yeah.
get back into that
The
same.
person is an individual, but nonetheless, they're two separate licenses, and as a licensee, they have the same rights in theory as any individual licensee as well.
Go ahead.
So who would you serve
You would serve the firm through the principal broker.
who's not there?
Excuse me?
Who's not there, right?
Well, I have no idea whether the principal broker is there or not, but that's what would happen, and we would have to get service against the firm after a complaint was opened against the firm. That firm would have an opportunity to respond to the complaint, and then, of course, it would go through the same process as before. If there there is never any service on it, it makes things somewhat easier for us, but is it individualized, is there not one and the same, even though it's the same person?
Well, if we went to their website today and it was advertising property management, is that reason enough to file a complaint?
That would be up to whether Ms. Maxwell believes it should be sufficient to file.
And I think in this instance, she probably owns the firm.
She does.
But if you have a third-party owner, we run into additional difficulties. And we can open a complaint against those firms and have those firms closed as well, if that's what the commission votes to do.
What are the additional difficulties you would run into if we try, if the complainant had filed against the firm and the principal broker in the beginning?
Well, the firm, in this particular instance, there was an initial firm, if you may recall. Later on, that firm closed and another firm was opened. And it's this other firm that's open that is still in existence legally. Not the firm that was involved with the same person in the complaints.
Well, just one more question. So there's a lot of money in escrow, in different escrow accounts, and if you close the firm, what does that do to the escrow account? Escrow accounts.
That, we don't have, we sent the auditor up there to the day of the Thursday of the meeting to go and try to verify what was or was not in the escrow account. The auditor reported that the individual was not there, and then when he ultimately spoke with the individual, she said she would only take orders from from Robin.
Not the best attorney you've ever had.
That's right. She said she would only take orders from Robin, but the problem is that we don't, as the commission, we do not have the authority to go in there and shut the business down, take over the escrow accounts. So that makes it very difficult for us to protect the money of the people who have it. And we got a number of phone calls last week from individuals who had been contacted by Ms. Jones, and she had said, no, I'm not closing my firm, and the commission was wrong, and I'm not going to, you can't move, I'm not letting you out of your management agreement, you can't have your money back. And that's what these individuals called and, called the office and wanted to know what the situation was.
And what did you tell them?
We told them that her license was revoked and that she didn't have a license to practice real
They
estate.
can all file criminal charges themselves, of course, and we can also refer to
Right.
about what Julie was about to recommend. But those individuals can also file criminal charges.
And they were told that too.
Yeah.
But that it is problematic because you can't go in there and seize that money like would happen if it was a tax lien. We don't have the authority to do that. I mean, is that?
I'm sorry.
Wouldn't you agree? We don't have.
I didn't hear what you said.
We don't have the authority to go in and seize any money, seize
Nope,
any
we have no
accounts.
authority to do any of that.
Lock the doors.
Nothing.
So, Julie, if we went to the DA in Sevier County, what would we tell them?
All we could do is, what we've done in the past when we refer things is we forward all the information to them and basically say that the Tennessee Real Estate Commission has recommended that this be forwarded to you to handle, because under the statutes, it's a misdemeanor. I can't remember what class. For practicing without a license. And really, it would be up to them to take whatever action they saw appropriate. We've had cases in the past where the DAs have taken action against individuals. I don't know how quickly the action would be taken or if they would do it. But, if there's enough push, then it has been done before. So,
Would her taking their money not be embezzlement or?
Well, that's not up for us to decide. That would be up to.
But that's what I'm saying for the district attorney. Would that not be?
Well,
the best.
Well, we could refer for that. We don't have any.
Right.
Probably the best recourse, and I think what Ms. Maxwell's been telling these people is you should any information you have, you should forward to these people, because coming directly from the individual who believes they've been wronged by somebody, the district attorney is probably going to look at that a little stronger than they would just a cover letter from me with documents. So,
But, Ms. Maxwell, if I may, approximately how many people that were involved in this have been in contact with you?
I think probably 4 or 5 of the people, and she had represented that she had 90 or 100. houses under management or properties under management. And that number contacted us. We've told people to contact the police as well. The police in Sevierville are very good about calling us and asking. There's a couple of detectives that seem to work on the cases that involve our licensees. They're good about calling. I've not had a call from them in the last week, but it may be that none of those people have filed criminal charges yet either.
But
It's not unlike other cases we've had where we, as a body, could not bring immediate relief to the public. All we can do is make certain that the individuals who've been harmed make an effort to let the local authorities know so they can take some action. That's the only way we were able to do that action in Memphis.
Well,
If we hadn't done that, those two individuals would probably still be doing the same thing.
But with that firm still having a license, she can get another principal broker to come in there and keep that firm open.
But she could in theory, but we have to approve any, like the principal broker has to be approved by TREC. So, that we could send an auditor up there as soon as, before a new person came in and see what the status of that money is. Maybe she'd take orders from someone other than Robin at that point. Our auditors can't force their way in. We can open a complaint against
Robin can. Go on up there, Robin. Take care of that, would you?
The auditors can't force their way in. It is a violation of 312 if they don't cooperate, but now she has no license. So,
we have no authority.
It's really it's a very difficult situation.
When we talk to realtors, we're going to bring a bill supposedly this session. I understand, is that bill is directly going to take care of situations like this?
We can't write the bill, so I don't know.
Give us more authority.
I thought they were going to give us more authority, and maybe some of those folks that are still involved in realtor need to check on that.
I spoke to one of the officers just last week about that, and they are definitely moving forward.
They are pursuing.
To try and draft something, and they would share with us before they would file.
So maybe at the next meeting, we can see something?
I don't know that. I can check and see.
Well, usually I think January is when they present the bills.
Yeah, legislative session to be starting like January 10th or whatever.
If I might, let me just raise one more point. If you recall from the testimony from one of the complainants, there were criminal charges being pursued against Ms. Jones, and the information and the final results of that hearing I relayed to both parties after the hearing. So they have the information and tools also to pursue something if they so choose.
Good. I've worried about all those people all month.
It was a lot of money.
It was a lot of money. And that woman shouldn't be allowed to walk away with it.
Okay. Well, sorry, because I don't have this in front of me.
If you all will let me take my leave, thank you very much.
Thank you. Merry Christmas to you.
Thanks, Robin. Merry Christmas.
I thought she was already done.
I know, I don't need to do that.
What should we do with your gift tomorrow?
That big bonus you were going to get tomorrow.
Julie, is there anything else?
That's all I have, unless you all have any questions about the consent order log. I just usually include it.
I'm not sure where the consent order log is.
I can't find it either.
Well, it was emailed to me.
That doesn't help me on my iPad here, Ozzy.
I can't even bring up my bookshelf now.
Oh, no, you've lost your bookshelf.
Lost my iPad.
You lost it. Okay, library.
Next month, I got
Does anybody know where the consent order is?
I don't have an iPad.
Do you want to
Come look at ours.
Oh, yours is up. Yeah. Consider it all, right?
Yeah, but there's nothing behind it.
Oh, there's nothing behind it?
nothing behind the cover pages.
He was just really trying to mess us up this month.
Typically, y'all don't have any questions.
Where's Kelly when you need her? Was Kelly doing all of this previously?
Obviously.
It may not be. She may not be.
I watched one time as a sort of not
I think you should have paid closer attention.
I should have paid more attention when I did it.
That's okay.
You want to give it to us next month if we need?
Yeah, that's fine. We can follow up with it next month.
Yeah, that suits me. Do you have a hard copy? Do you want to put that off till after the education report? Right now, I'm looking for the,
The education report?
you want to do that?
It's the second one from the left.
It's actually right next to what says education report.
Where's your report?
Okay.
Okay,
It's sort of spread out throughout here.
Page 1 of 1.
okay.
I found it.
Well, wait a minute, Steve's doing the consent order. Where's the rest of the agenda?
Right here.
Stop beating us. I don't know.
I don't have one.
Are we going to the education report?
Well, that's why we're going to go
We're
to the,
passing that just around if anybody has any questions. It's just a log of what's.
we're going to look at the, we're all going to
You
look
can-
at the consent order
You
log.
can just glance at it and see if you have any questions.
I know there's several that hadn't paid in a long time. What are we doing with those?
They've been forwarded to litigation if it hasn't been satisfied.
Before we,
Well, I can't read it anyway.
if I can say one thing, before we leave Julie's report, again, I want to recognize Connell House, who does a superb job working with Julie and handling all these complaints for this real estate commission. And we do appreciate the job you do for this commission, Connell. I can do that as a commissioner. You're in
Okay.
charge.
Okay, should we go on to the, any questions on the consent order log? You're the one, you're supposed to be looking at it, Commissioner.
I make a motion we approve the consent order.
I have a motion, we approve the consent order by Commissioner Collins and seconded by McMullen. Any discussion? All in favor? Aye. Opposed? Motion passes. Let's go on to the education report. Are you ready? Where'd he go?
He's
Yes,
over
ma'am.
there.
Thank you. I had to get to a microphone.
Okay.
This is a rather lengthy education report because most of the providers have held off to December to put their courses before approval so they wouldn't have to pay a renewal fee back-to-back for getting a course approved because all courses had to be approved by September 1. So the majority, the bulk of these courses are coming to you now as a cost-saving measure for them so they could have courses approved for 2013-2014. There are 2 courses that I'd like to bring up for discussion, and we can talk about those after you review the other 45 that are before you now. And as always, I have the backup material with me if anyone has any questions.
Steve, on the
Ma'am.
new core course that
Uh-huh.
D&D School of Real Estate
Correct.
has written, are they the only ones that submitted Career Institute and D&D? Are they the only ones that submitted core?
For this month,
This is one of the success as well.
And degrees and stuff.
I can tell you how many we've gotten approved thus far.
Do they all look pretty standard with each other?
They do.
I move to approve the first 45.
Second?
Well,
If you don't mind for the repetition, I'm also helping Eve do the minutes. Who made the motion?
McMullen.
Okay, thank you.
Mullen and
I made the second.
Collins was the second.
Okay, thank you.
Is there any discussion? Because I have a question.
Okay,
I'm looking at the course that talks about 1031 tax-free exchanges, et
Yes.
cetera.
What page are you on?
I have no idea, 3 or 4, 4. And
Here's course number
the,
41.
well, for instance, if the tax laws change next year, which they very well might do, is, what do we do with this course?
Well, they would have to...
Because we've proved it based on current laws. Current laws may change in less than 30 days.
Any significant changes to a course have to go before the commission before they start teaching them in the future. And this being approved through TREES, TREES historically has done their part in educating licensees with the most current information. With your recommendation, I can make sure that any courses that, to all of our providers, not necessarily just this one, any changes in laws that come to be January.
Well, apparently there's going to be quite intricate changes in laws that we may not even know all the implications for months. So, I don't know.
We can ask those providers to ensure that they make the following changes to their coursework.
Okay, well, it was just a question. Any other discussion?
Well, you've got the same problem with course D20, which is real estate taxes, what every agent should know.
Yeah, I can see that we'd have several.
Talking about mortgage interest deductions
and we don't, could be months before we find out exactly what's going to happen.
Yeah, is this going to be before or after we fall off that fiscal cliff?
It sounds like after.
It's after we fall off the cliff.
And I know 1031s are up for discussion, definitely, and it probably aren't going to be around, which I'm not going to give my opinion on. So.
30% of people take mortgage deductions, interest deductions.
Pardon? I couldn't hear.
He said less than 30%. There's about, give me a little bit of trivia that I've learned.
You got to itemize to take it.
Yeah. But to give you a little bit of trivia that I've learned at an Arello conference one time, we've got about 104 million houses in America. About 54 million of them are paid for. Well, there's no interest deduction. About 50 million of them have a loan on them. Today, about a third of those, the balance on their loans more than what their house is worth. Another one of the problems we're in the midst we're in.
Of course, if interest rates are 3%, the deductions aren't going to be big enough anyway.
That's true. They're going to be small.
Well, I guess my question, because those two are so pertinent right now, are the 1031 tax exchange is one that I deal with all the time. When those laws, if those laws do change, do we go in and we make sure, and I think you answered my question.
Okay. And there's more control over it because it's a classroom course. Those changes can be made instantaneously versus a paper and pencil that could already be sent out to someone.
Right.
Call for the question.
Call for the question. Thank you. All in favor?
Aye.
Opposed? Hearing none, it passes.
I got a question about the other two.
Yes, sir.
The other two.
The CCIM course is an old course that was not updated.
Correct.
What expecting to get credit in this period as opposed to the previous?
Correct. The provider did not get the approval for the course that they gave. They just used the same course number. So, correct. So what happened, 12 individuals took the course that took it the year before, and because the licensing system looks at that 2-year window, that same course number came up and it kicked it out for the second time. The provider knew that any changes in material had to be presented to the commission for review. There's 2 rules that speak to that. It's just an unfortunate case where these 12 individuals took the same course, though different material, but took the same course number. And the reason why it reflects on this educational report is the provider is sending it in.
Penalize those that took it or reward the person who was closest to it.
Yes.
And these people got in touch with me, and that was the reason I asked Steve to at least put it on the agenda for discussion. because there were some people who, like I said, 12 people who took the class. This is a annual economic forum type discussion, and so it's the same title, but they do new content every year based on the anticipated economic conditions for the coming year. And it looks like the organization dropped the ball as far as sending in what they needed to send in order to get it approved.
And as Commissioner McMullen just stated, there was a Post-it note on the last application submitted from the provider stating that the next time this course is offered, they would send in a new application to get a new course number. I pulled it from the box. I sent it to Commissioner McMullen. So unfortunately, the ball was dropped. And Betsy and I mean, we do our best to communicate the rules over and over again to our providers, but unfortunately, this is just a mistake that affected 12 folks.
Do you think it was an oversight, or they just deliberately did not think it was worth sending?
I think it was an oversight. I think the provider just didn't do it.
Is this a provider that has several ongoing courses?
No, there's
or
only
is
3
this just-
courses they have approved. This is the one that they have every year in the mid-state that's of significance. The other ones pertain to that CCIM designation. They get really specific about CCIM stuff.
These individuals rely on these credits to get their designation.
I can't speak that this keeps the designation class since it's an economic forum. I think it's updates because the folks that typically give the updates are like the Chamber of Commerce president in Nashville. The 2 people that are listed on here that were not previous speakers, Richard Fulton, I mean, if you're from the Mid-State, you know Richard Fulton. And then
Is that the Richard Fulton that?
Yeah.
Former mayor
here? Okay.
So all I have the ability to do is to look on the rules that are set forth with application process and the repetition of the course and put it before you to discuss.
The other CCIM designation courses are approved by this body.
Yes. There are 2 different course numbers. One is like national, and the other one is specific to the mid-state region.
Those are approved by way of the National Education Director, not the local.
Correct. The 2 providers. Mail would go, the one that we're discussing now, the mail goes to Donaldson Pike. The other class is the significant list that people take across the state, I guess is Michigan Avenue in Chicago.
Has this organization followed up to actually submit, even if it's after the fact, what would have had to have been required to be submitted in order for it to be approved?
Yes, it was submitted, unfortunately, it's over there, within the last week or so.
Okay. But it was after the
And
fact.
this course was given in October.
Was it a summary of the meeting? It sounds to me more like a meeting where they had speakers come in and talk about their sense of what's going to happen. Is that your sense of what it was?
That is the economic forum, correct.
So I don't know how they give you a curriculum in advance. I understand. I think getting it after the fact and saying this is what people said makes as much sense.
Well, I don't, do the speakers have handouts or materials or something like that?
It's my understanding that they have to put this presentation together ahead of time so that these speakers can come in and talk. Also, the rules talk about the application process. We have to give it approval ahead of time.
Do we have the authority to approve this course after the fact?
I'd have to defer to legal on that.
We had this same situation happen in our association where it was a CRS course. And people paid for the CRS course, came and took it, and it did not get on this agenda until after the class was given. And those agents did not get that credit for that CRS course because it had not been approved at the time the course was given.
The only place I see in the rules A rule that I see that appears to apply here would be 126509, changes in applications. Any material change in information furnished in connection with an application for approval of a course, including but not limited to information concerning course content, instructors, and facilities, shall be submitted to and approved by the commission before taking effect. I don't see.
Why couldn't the provider return their money and offer it to them again after it's approved and give them credit for it? Wouldn't that be a simple solution?
It's an option.
And you're opening the door when you do that.
Well, if you approve it, you do.
Yeah, we all did approve it.
And also, did you say that some of these people had already taken the course the year before? Did I understand you correctly?
They took the same course number, but it was a different course.
So, if it's the rule that says a licensee will not receive continuing education credit for classroom hours completed during a prior license period, would that not, if it's the same course number,
because they didn't change the course number.
would those licensees not have known I took this during the year before? If they were aware of the rule, would they not have known that if it was the same?
And it could have been 12.
Would it have been on advertising materials? I don't know.
Well, if you take the same course every year.
You know if it's easy the next time, don't you?
Well, it's
A revised course would have qualified.
So you said that 12...
If they change the course number or change the name of it. But they have to do something to indicate to a licensee that it is a different course for them not to know that you can't take the same course twice in the same licensing period.
As I understand what legal just read, we don't have the authority to do anything in this case.
I don't see that to be the case here. I'm missing it if there's something there.
But if you want a trial,
Well,
I think they...
There's really no indication it's the same 12 people, is there? Do we have any reason to think that the same 12 people took the same class 2 years in a row?
Well, I've got the roster that provided the error load sheet, and the error comes back duplicate entry within licensing period. So that's...
For all 12 of them? Or?
For the 12 people, correct. It's the same.
12 people that it affected.
But the course was never approved at all, right? So were there more than 12 people who took the class total and none of them got credit?
It was approved previously.
This course was approved in 2010.
So the people who were taking it for the first time, even though it was a different material, got credit for it really based on materials that really didn't apply because those weren't the materials being used that time.
And then we switched at the end of, or midway 2010, from a 4-year approval period to a 2. So that's where the Post-it note was applied saying I'm approving this course, but I will be seeing another application to remedy, unfortunately, this situation, and that never came in to the Real Estate Commission.
12 people that took the course twice got two sources of information. They didn't get the same information because
Right. It really was a different course. It was just the same name, but it was a different material.
All it had done was change the numbers of it. It would
Correct.
never fit. It's a computer.
Well, it's also the fact that they never sent it in for the second approval.
That's the problem.
And Betsy and I don't have that ability to award them credit without this discussion. So it would set the precedent for us for every education class in the future.
Well, and as an instructor who has written courses, we have specific guidelines that we have to go by, and that course writer knew that had to be resubmitted. That goes back to a instructor or a course writer issue.
It's like you're talking about something you can't do anything about.
I don't think you can either. I think those people just can't get credit for it.
How many hours?
They got the knowledge, they just didn't get the...
Yeah, how many hours?
A 4-hour course.
Oh, yeah, I see.
Well, I don't
I'll ask
dis-
one other question. Does this put any of those individuals in jeopardy of not being able to renew their license?
I would have to look at each individual's case-by-case basis. Unfortunately, with the load report, it doesn't get that detailed.
Can we defer?
Well, what good's deferring going to do? I mean, just because
Nobody's making a motion.
well, there's no motion to be made, there's nothing we can do.
He's asking for guidance. We need to respond.
That's right.
But
what do
by
you-
no motion, that is a response. There's nothing we can do.
Move to approve the course.
Second motion.
I have a motion by Commissioner McMullen to approve and a second by Commissioner Stevens. All in favor?
Well, I have a question.
What
Are
about
we
the
just approving?
Discussion, sorry.
We're just approving the course, right? That's not going to have any effect on the people that's already taken it that we're talking about.
And when this course is given again, the
It's gotta
course
be
number you
revised
give it
again.
today will not be the course number that needs to happen next October or the end of next September.
Against it, too.
Well, I thought that you said she had submitted an application after the fact to have it approved
Which is
retroactively,
Which
right?
is this right here that you're looking at. Yes, sir.
And so that's what my motion is to approve it retroactively.
Oh, okay.
Was that your second?
That was my second. I thought that's what he meant.
Steve's going to write that down. Any further discussion? Any further discussion?
If the motion passes, those 12 people who've taken this course twice are going to get double credit. Is that the sense of this, of your motion?
Well, I don't really consider that they've taken the same course twice, because the first time it was 2011 Economic
setting a
Outlook,
precedent.
and then a year later, they come back and they take 2012 Economic Outlook. Now, they may have had the same number due to a person not timely submitting the application, but it really wasn't like you sat through Algebra 1 twice.
Since you are giving this a new course number, those folks, since we have the load sheet, we can go in manually one by one, void out the prior course that was mistaken, and whatever course number this generates after this meeting, we go in and put it, that way no one is in jeopardy.
How do
So
we
that-
do this and not set a precedent?
You are setting a
But
precedent.
you are, and that rule does say that any change should be submitted and approved by the commission before taking effect. That's what the rule says. So this is going to be, if this comes up down the road, I mean, I realize those people have taken the class, but there's also the person giving the class that
I second this motion, based upon what you just said. We're attempting to do something we do not have the authority to do.
based on my reading of this rule, that's what it appears to me.
Commissioner McMullen, no matter how much I feel like this, it'd be nice if we could do this. There was they had different courses. I mean, they sat through with 4 hours of different material and different discussion each time. But if we can't do it, we can't do it.
Well, here's what I'd suggest, that you keep your second in place, and Commissioner McMullen brought this on behalf of Middle Tennessee people. We can at least give him the benefit of a vote, he can go back and tell them he tried.
Okay, I'll keep my second in place.
Is there any other way that they can
Can I
get
make
course
one
hours?
other comment?
You can.
In '09, when we went to changing the cycle, there were courses that were not approved, that we didn't approve going forward, even though there were requests to do so. We didn't do it then. We shouldn't do it now, because if we do, we're going to have problems or potential problems with those individuals from '09.
Yep.
So I'm going to vote against the motion.
Okay, any other discussion? Okay, all in favor, say aye.
Aye.
All opposed?
No.
I think the noes have
Mr.
it.
Alexander's vote.
You said we have 2 ayes? Do we need a roll call?
No.
7-2.
It's only 8 of us.
6 to 2. I'm
6 to 2.
It's a long day, folks.
Okay, Steve, what else do you have? I know you're writing notes too.
Okay, the next course number, there's no issue with this. However, it is the first of its kind since the new law took place June 14th, 2010, requiring that anyone teaching a core course take a core course instructor training course. That's a lot of courses. I'm getting tired as well. Jim Gibbs from Career Institute has put together the instructor course for the TREC 2013-2014 core course. It's correspondence, and it is to help facilitate compliance with those other instructors that are taking, or those other instructors that are wanting to teach the core course. The other provider that
I thought you were going to do that.
puts this together,
I thought we hired you to do.
I thought, yeah.
well, that's our next thing of
I was
discussion.
going to send you to school to get education
Well, they
on all
didn't
that
have that class.
curriculum.
We're going to get ready to talk about that.
We'll talk
Because
about it.
unfortunately, that's not my job plan,
What?
nor the budget. I do have an instructor training manual that I would like to discuss in just a moment, but this doesn't talk about the core course.
So what do you want us to do with this?
Well, I just wanted to talk about it because TAR previously has been the only provider to give a core course training. This is a provider who has provided real estate training for some time, and this is the first core course instructor guide training that has ever come into the commission.
Do you like it?
It's good. It's well developed. It's very well developed. The section on contracts does not it does not speak to just the TAR alone. It gives a component of the law of agency. It talks about instructing to adult audiences.
Would it be something you would use too?
I think it's beneficial. I think that Mr. Gibbs did a very good job.
Steve, can I look
Yes.
over that?
Do you want to take it with you?
I'm not
Please.
opposed to approve it based on personality, but
You can
didn't
get
we
it
talk about
afterwards.
Arello being the entity that would conduct the courses for the instructors?
No.
I thought we talked about Steve.
Well, we
Absolutely.
talked about Steve, but we talked about Arello as well. And if Steve is not going to do it,
Well, I don't know how Arello's going to do a core course for Tennessee.
No, he's talking about
The instructor training. That we'd have to submit a request to administration to request those funds to hire Arello to conduct that course, and then look at the feasibility of giving it across the state to these individuals that are going to be within the state, teaching at classroom.
I think last year, Isaac, in the TAR core instructor training class, there were about 40 people that came to the class to be certified as instructors. And right now, like Steve says, they're the only ones doing it, but if Jim's got a class too,
And so those 40 people are already trained.
they were trained in the 2011-2012 core instructor class. There will be an updated core instructor training class in January for the new core course.
And this is totally,
This Jim's is totally separate and apart from that.
so this would be to instruct new
Instructors
And those that
or
are not affiliated with TAR or want to come to TAR.
does the statute specify any required credentials for the institution that provides the training for the instructors?
Only what's provided for in Rule 126504, which in the old manual is 78 and 79. And Mr. Gibbs is a approved provider and broker.
he's not ever had any complaints or anything filed against him
No.
or anything
Let's not
that
go
would.
there.
Well, we need to go there. I mean, we need to know if we're going to have people training that are doing it properly and haven't had any
Go ahead.
issues.
Since March 2010, I have not had a complaint presented to our office on Career Institute or Mr. Gibbs, who makes regular appearances
Good answer.
to our commission meeting.
Steve, do you remember us talking about you getting all the instructors in and training them?
Yes, sir.
Is that something in my imagination?
No, sir, and that's part of the discussion I wanted to have in just a moment with instructor training manuals, with something that Director Maxwell and I have discussed while discussing this topic.
Are we going to do that this afternoon, because it's already after 4?
That's up to you.
That's why I want to look at Mr. Gibbs' manual. Steve's.
Yeah.
Yeah.
I think this is a good place.
And-
Take this conversation.
And maybe you could give that,
Sure.
people
How
that
about with
want to
me?
look at it could look at it this evening, and then we could discuss it tomorrow?
Absolutely.
Madam Chairman, I move that we adjourn for the day.
I have a motion that we adjourn for the day. Do I hear a second? Second for Mr. Northern. All in favor? See you guys.
Make sure that you sign out for today, please.
Sorry, Steve. I should have said give instructions. Go do that. Which one?
Do you feel pretty good about this one? Well,
I'll go right there. I'll go and I'll refer.
Kelly knows all
Oh, well.
Karen's not here. Talk to Jan. She's the one that's looking over all of it.
They got a record here.
Janet, did you hear anything?
what?
I think you need to find out on this.